change how we operate, we are still committed to a transparent process and encouragement of public comment during our meetings. We will be accepting public comments based on using the hand raise feature. You can raise your hand at any time and we will recognize you as we get to the public participation portion of the agenda for each case. Director of Planning, Joe Vunich, will be moderating the Zoom meeting and will be asked to provide names of those individuals that wish to speak, again, as hands are raised. I would like to call the meeting of the City of Wildwood's Board of Adjustment to order. The board members present today are Deborah Coleman, board member, Arnie Sprunger, board member, Daniel Sides, alternate member, Jim Rubis, alternate member, and myself, Jared Frank, vice chair and acting chair for tonight's meeting. The Department of Planning staff present is Joe Vunich, Director of Planning, Robin Keefe, Planner, City Administrator Steve Cross, City Attorney John Young, Assistant City Attorney Sam Beffa, and Court Reporter Courtney Tallman are also present. First, I offer into the record the affidavit of publication pertaining to today's meeting, February 7th, 2022. And take official notice of the zoning ordinance of the City of Wildwood, including Chapter 400, Article 2, authorizing and establishing the Board of Adjustment's powers and duties. Now let me explain the hearing procedure. Please be aware the information I am about to describe is also provided on the Board of Adjustment public hearing procedure handout, which was available online prior and up to tonight's meeting. This hearing is informal in its nature. However, the meeting's procedures will be recorded by a reporter for future transcription if needed. The petitions are called in the order listed on the agenda. As the petition is called, I will ask a Department of Planning staff member to read each request into the record. Thereafter, the Department of Planning will have opening remarks and a brief slide presentation. Then the petitioner or his or her representative will be asked to state their name and address, be sworn in by the court reporter, and make a brief presentation to the board explaining the nature of the requested variance and the hardship necessitating it. The board will only consider the nature and condition of the property and whether these factors mandate a variance in order to allow for its full utilization. Board members may ask questions to clarify the facts of the petitioner's presentation. When the board is satisfied with the material presented by the petitioner, the chair will then ask if there is anyone present online who would like to speak in favor or opposition to the request. Each speaker will be asked to provide their name and address, be sworn in, and then state their comments. Procedurally, the petitioner may request a continuance at any time during the hearing, prior to a call for the vote, in order to bring an additional documentation or information. The board may also request a continuance to gather additional information or for a further visit to the site. After the conclusion of input from all interested parties, the board will ask a staff person to provide the Department of Planning's report on this matter. If required by any member of the board, the petitioner, or any individual that is participating online. Additionally, any other information not presented in the previous testimony but pertinent to the request will be noted at this time. Once all speakers have been heard, the chair will call for a motion to grant or deny with or without conditions, then the board will vote. At that time, the discussion relating to the petition is concluded and no further input will be permitted. The board will generally make a decision today. 4 members of the board must vote in favor of the petition for it to be approved. If a variance is approved, the petitioner has 6 months to obtain the necessary permits or establish the use, or it will expire. If the board's decision is unfavorable, the petitioner has the right to appeal to the St. Louis County Circuit Court. This appeal must be done within 30 days of the decision. Mr. Vunich, are there any questions at this time?
Thank you, Mr. Chair. To those in attendance at tonight's meeting, if you have any questions regarding what was just read into tonight's record by the chair, if you would please use the raise hand feature. Once I recognize the raise hand feature, I will promote you to a panelist so you can ask your questions. Thank you. Mr. Chair, no one's raised their hand, so I think we can proceed to the next step. Thank you.
Okay, hearing no questions at this time, the board will proceed. Notice is hereby given that the Board of Adjustment may also hold a closed meeting for the purpose of dealing with matters relating to the following: legal actions, causes of action, litigation, or privileged communications between the city's representatives and its attorneys. At this time, may I have a motion to enter into a closed session?
Mr. Chair, before that motion is provided, would you mind reading the citation? I think it's RSMO.
Yes, I apologize. Let me just read that sentence again. Closed meeting for the purpose of dealing with matters relating to the following: legal actions, causes of action, litigation, or privileged communications between the city's representatives and its attorneys, according to RSMO 610.021, parentheses 1, 1994.
Thank you, sir.
At this time, may I have a motion to enter into a closed session?
I'll make a motion to enter into a closed session.
Can I have a second to that motion? Mr. Rubis.
Mr. Rubis, if you could unmute.
I'll second that motion.
Okay, at this time, we'll take a vote to enter into a closed session. Member Coleman, how do you vote?
Yes.
Member Sprunger,
Yes.
member Sides,
Yes.
and member Rubis.
Yes.
And I myself as chair vote yes as well. We will now, I'm sorry, go ahead, Director Vunich.
So, Jen, with your permission, Mr. Chair, to all those in attendance tonight, the board and its attorneys will be leaving the meeting. Please stay on the Zoom platform. Mr. Newberry will be there to assist you if you have any questions. And we appreciate your patience as we do the closed session. We'll do it as quickly as we can and return to the regular meeting. Thank you.
Mr. Rubis and Ms. Coleman, if you would click the red sides, click the red button at the bottom to leave the meeting, and then click the second link that Robin sent to you earlier today
Okay.
via email.
How long do you think they'll be on closed session?
Just a few minutes, I think, is my understanding.
Like 5?
I would guess they will go that long. Yeah. Yeah. I'm going to turn my video off and share my screen to let the folks on YouTube know that it's in closed session. So,
Okay, I'll come back and check in 5 minutes.
okay. Mr. Chair, thank you for your patience as I bring everybody back in.
Yep, thank you, Travis.
Mr. Chair, I could hear and see everything that was going on in the closed session. For some reason, I think they were using my account. We have two Zoom accounts, one of which is mine at the city. And I think there's somehow, by using it and then trying to get in through the link, was blocking me from joining as a panelist. But Travis and I will troubleshoot that tomorrow. But I was able to, and I could even enter a comment into the chat room, but for some reason, I couldn't be brought in as a panelist, but I did hear and see everything that was discussed, so.
Okay, thank you.
Mhm.
We'll wait just one more moment here for everyone to get back in. Let's see. Looks like we have everybody. Is that correct, Travis? From a board standpoint?
Mr. Chair, I'm running down the list. Mr. Strong. Yes, sir. Looks like we have all of the board members, as well as Mr. Young and Mr. Buffa, and Mr. Cross and Mr. Vunich and Ms. Keefe. So,
Okay, well, thank you everyone for your patience. Director Vunich, are we ready to proceed with reading the first request into the record?
Yes, sir, Mr. Chair. The first request tonight is Board of Adjustment Case 03-22, Tim Klingler, 930 Wilderness Way Drive, Eureka, Missouri, 63025, care of John Taylor, P.O. Box 127, Pacific, Missouri, 63069. Requests an exception to the natural resource protection standards for the purpose of constructing an attached three-car garage upon the property located at 19023 Old Wild Turkey Lane, locator number 28Y130123, Timbers at Fox Mountain Subdivision, Lot 6, which would thereby authorize relocation of the identified natural resource protection area, as well as its associated 25-foot setback area to accommodate the placement of the proposed structure, as well as associated grading, while maintaining the approximate amount of preservation area on the overall parcel of ground, i.e., an exchange between preservation and building areas. This request is contrary to the requirements of Chapter 420-200 Natural Resource Protection Standards and Procedures of the Subdivision and Development Regulations of the City of Wildwood Municipal Code as applied to properties located in the NU Non-Urban Resident District and Chapter 415.090 NU Non-Urban Resident District Regulations of the City of Wildwood Zoning Ordinance. This particular property is located in Ward 6. Mr. Chair, before Ms. Keefe provides the slide presentation tonight, the Department of Planning would like to enter into the record the following items: the Charter of the City of Wildwood, the Master Plan of the City of Wildwood, updated in 2016, Chapter 400, Article 2 of the City of Wildwood Municipal Code, the Board of Adjustment, Chapter 415, the zoning ordinance of the City of Wildwood's Municipal Code, including Chapter 415.090 NU Non-Urban Resident District, the file that has been developed and maintained by the Department of Planning regarding this particular request and all contents contained therein, including the department's recommendation report. And then finally, any testimony provided tonight, including any exhibits, maps, plats, photographs, or other evidence offered as part of the cause. Thank you, sir.
All noted. Thank you. At this, oh, sorry, Robin, you're going to get perfect. Thank you. I believe you're muted still, Robin.
My apologies. Thank you, Mr. Chair, members of the board. Our first case this evening involves a subject parcel located in the far southwestern corner of Wildwood. This parcel is located in the Timbers at Fox Mountain Subdivision, which contains 8 large lots, residential lots. It is an undeveloped subdivision as of yet. And the construction project being proposed would be the first of its kind in the subdivision. Lots in this subdivision range from 6.6 acres in area to almost 19 acres in area, which is well under the density allowed by the non-urban residential district in the city of Wildwood. This has resulted in 64 acres in this subdivision being protected by the natural resource protection standards out of almost 78 acres. The subject lot is 8.08 acres in area. It is densely wooded and located at on top of a hill. And here you can see that the summit of this hill is located around this cul-de-sac. Old Wild Turkey Lane terminates at this cul-de-sac. And there is over 110 feet of overall relief on the property. The applicant this evening is proposing to build a new single-family dwelling on this lot with a 3-car attached garage, which is the subject of this request, along with some associated grading. On this graphic, in dark green, I have outlined the final resource protection line. And then the lighter green is the 25-foot foundation setback from that line. In red, we have the building line, denoting the building setbacks. And this black line is the property line. Here is the 3-car garage, and as you can see, just about half of it is located within that foundation setback area from the natural resource protection line, but it is located outside of the building setback. The grading being proposed with it is located in the natural resource protection area itself, and it is located in the building setback area. This lot over here is related to this request. We'll discuss it as part of our next case. But here you can see both lots, and what is being proposed in order to accommodate this construction is a natural resource protection area swap of equal areas. So in this case, area A represents what would be swapped with area B, which is just around 3,000 square feet of area. So we'd be taking it from this area to the back of the lot, or back of the building area, sorry. Here you can see a picture of the cul-de-sac from the lot, and here we are looking north and slightly east. And here we're probably seeing more of lot 5 than we are lot 6, which is the subject of this request. But in this case, we are looking east. Looking west from the cul-de-sac. And perhaps slightly more west into the north. Still looking west. Looking north. Looking south. Southwest. West. As you can see, we went out a few different times. Northeast and northeast. And it should be noted that on one of these site visits, I went out with our assistant city engineer from the Department of Public Works. And the Department of Public Works has noted that They do not oppose the associated grading in the building setback area. So the primary subject of this request is that it's in that natural resource protection area. The department has received one comment in opposition, which is in your possession. And with that, I'll conclude my presentation. And if you have any questions, Director Vunich and I are here to answer them.
I have a question, Robin, or Joe. When I looked at the material that was sent out, I saw how the natural resource protection area was actually drawn up. I'm trying to figure out how in the world does anyone draw things up like this? Because it's almost an odd rectangle type shape that goes right up to where their garage would be. It just seems strange that would be up like that. And it's kind of a question, but the other comment then is, it looks like in terms of like grade, and I know we're trying to protect against erosion and that sort of thing, but it looks like the grade where they want to do the swap is fairly similar to where, you know, the land inside of the protection area is. So it was a little confusing to me how in the world these protection lines even get drawn in the first place.
Well, if Joe would like to chime in, he is welcome to, but I'm sorry, Director Vunich. But my understanding is the natural resource protection areas were originally, they were created when I believe soil scientists are involved and expert consultants that go out there and determine what areas of the lot are of most important to preserve for erosion purposes and ecological value, et cetera. And they do their best to position a buildable area on the lot in association with those characteristics, but it's not always perfect, which is why there's some flexibility within our standards. We're adjusting it from time to time to fit what is actually being proposed for construction. And in this case, the applicant noted on the plans, and I think you could see that, you know, just north of the proposed house, it had a pretty substantial grade. And so this was just a little bit better for his project.
Okay, thank you.
At this time, I'd like to call the petitioner forward. Please state your name, address, relation to the property, and then be sworn in by the court reporter.
Tim Klingler, 930 Wilderness Way Drive, Eureka, Missouri. And I am the owner of the lots.
Okay. Courtney?
Please raise your right hand. Please raise your right hand. I'm going to swear you in.
Mr. Klinger? Oh, there you go. Thank
Okay, there you go. Do you solemnly swear that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, Mr. Klingler, the floor is yours. Please proceed.
Yeah, so we, the biggest part of, and if there's any questions that arise, my civil engineer is also on here. He can raise his hand and answer anything. Mike Boucher is his name. So we're trying to keep the home as far to the north as we possibly can, which in turn put us outside of the natural resource line. And it's mainly due to the severity of the drop off to the north side of the home. With that, we also are trying to grade between the two lots that we own, which is on the property line also, which puts us outside of the natural resource line, to basically a couple different things. Flatten the front because it's 6 to 8 foot from when you're standing at the cul-de-sac coming up. So we're trying to do some light grading to level that off to be able to see the home. That's going to be about 75 foot from that cul-de-sac. And then also to have better curb appeal on both lots, but then for a future homeowner to the left, south, lot 5 as well.
Okay. Is there anything else you'd like to add, Mr. Klingler, before I open it up for the board members' questions?
I do not.
Okay, thank you very much.
Thank you.
Members, any initial questions? Hearing none, at this time, I'd like to open the floor to speakers in the audience.
I had my hand up. I don't know.
Oh, I apologize, Dan. I didn't see you there.
Yeah, I've got a couple on the, so the proposed area in red, that's all grading. Can Mr. Klinger or anybody else, can you tell me the shape of the grade of that grading? I mean, is it going to be, obviously it's going to be higher towards your house? Does it get lower toward the other lot? Or just kind of describe that for me.
Yeah, so you mean between the two lots, I guess, which would be left of the home, kind of south. So the grading between the two lots is going to be fairly level. And if you are, let me turn this one, Mike, you can jump in here as well if you want to raise your hand. Because he does have the diagram.
Well,
Yeah, well,
basically on the,
Just a moment, Mr. Is it Boucher? How do you say your name?
it's Bisher.
Bisher, I apologize. Mr. Bisher, can you please state your name, address, relation to the property, and be sworn in by the court reporter?
Absolutely. My name is Mike Bisher. I am a civil engineer. I live at 14851 Remington Road in Marion, Illinois, and I am Tim's civil engineer.
Okay, please raise your right hand. Do you solemnly swear that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
All right, thank you, Mr. Bishler. Go ahead.
Certainly. So to the left of the house, basically we're going to cut down the existing hill, and the plan is to take out roughly 6 feet of that hill. So we will have a gentle slope, about a 2% slope from the proposed garage south to the and into the other property. This will allow the other property a much easier access and be able to sell it off in the future with a more buildable site, if that makes any sense.
So the swapping of these natural boundaries, I'm having a little trouble visualizing. So the D and the B in green, is there something actually being done there, or is that a natural?
No, sir. That's just, so it's just the natural protection area is going to increase in those green areas. No work is going to be performed. And the natural resource protection area is going to decrease in the red areas. Ultimately, the whole idea is to give you the same amount of natural resource protection area that we started with. And that's why we're doing this so-called swap.
So you know the grade better than I do. If you're standing against Mr. Klinger's garage looking towards this new grading, does the slope fall more toward the back or toward the new lot, the other lot? Lot 5?
Towards both. It's going to slope both towards the back and towards the new lot, the other lot, the south lot.
Okay. I don't see how B comes into play then at all, but
Well, sure, because I have to get rid of A. In order to do any of this work, I have to get rid of A. I'm not allowed to do any work in the natural protection area, and the existing area is A. And I want to get rid of that and give you B instead.
So if I may, if I could just increase the explanation there, we're relocating the natural resource protection area on the lot. So it's going to increase the area from the back of the buildable area and allow them to pursue their construction where it currently exists, which is closer to that cul-de-sac. So,
well, I understand the concept, but I don't, without being, I mean, without really being able to calculate this or be on the land, it's a little hard to tell. I do know that from personal experience, living on a hill in Wildwood, that as soon as somebody builds a little higher than you, if it's not done perfectly, you can get a lot of water, because we deal with that all the time. That was why my main question as to how the direction that's going to flow into that lot 5. And you're kind of telling me that it's going to flow as much equally in each direction back and towards lot 5, it sounds like.
I believe that's correct. Yes, sir.
And also, just if I could add, if you're looking at the property line between 5 and 6, there's basically a valley going down the, it will slope away towards 5, but there's also a valley that goes right down the property line. So towards the southwest. So it's going to slope both ways, as Mike was saying, towards the south and southwest.
So the valley will start after your new grading then. Is that where it works? You're going to fill in the valley between the 2 lots with your grading?
Tim, you kind of lost me there. You're saying there's an existing flow path between the 2 lots, if you want to call
No,
it that?
I guess what I meant was, yes, it's going to flow to the south. I'm thinking further back down the property line is where that is. So really, it's not even in the grade line.
I mean, as I look at the diagram, the topo diagram, it looks like kind of already there's a bit of slope between the lot that we're talking about now and I'm sorry, I don't know which one's 5 or 4 or 6 or whatever, but it looks like there's already some fall from this lot to your next lot. Am I seeing that right or am I seeing that wrong?
No, you are correct. I don't know what exactly sheets that you guys have. Do you have a sheet C1 that shows the proposed building and the proposed grading?
Robin, could you bring back up one of the, thank you.
Is there a picture that shows the finished grading?
Sorry, if you'll just give me a minute, I am going to pull up the petitioner's plans. Now I'm going to share my screen. Okay, and so everyone should be seeing the sheet C1 that was just discussed.
Okay, so Robin, can you zoom in for me around the new driveway and the property line south of us? There you go. So just south of the driveway that goes into the 3-car garage, there's a proposed contour elevation of 94. South of that into the next property, there's a contour line of 93. So there's a 1-foot fall there, okay? If I go north of the 94 contour, there's another 94, which means there's a high point in between. So very little pavement from the driveway is going to flow south. Most of it is going to flow towards the north, and you can follow those contours, 94, 93, 92, until they go off north. The roof area for the garage should be collected by downspouts. There's a line behind the whole house labeled DS, and that line goes all the way around to the north side of the home. And we have a proposed flow well, which is going to mitigate the excess storm water. So we're not introducing any more excess storm water. That's the idea anyway. Does that help, Dan?
Yeah, so that 94, 93, that's the finished grade.
Yes, sir. Proposed.
And so it goes around farther than actually our little red rectangle. It goes around to the back of the house somewhat.
Right.
And then the next, okay. Yeah, that does help. Yes, that answers my question. Thank you.
Wonderful.
Any other board members at this time have any questions? Seeing none, I'd like to.
Yeah,
open it.
Jared, just one
Yeah.
other question. The grading affects another lot. Is that lot owned by the developer or is it owned by a private owner?
Are you referring to owned by the applicant?
Well, the applicant
that what you're
in its grading, he's talking about the grading will affect the other lot.
That's, yeah, we own the lot 5 to the south. The 2 we were just looking at, we also own that one as well.
Oh, okay. All right. That's so.
And for clarification, that will be the lot under discussion. In our next case, we divided them up, so there's 2 decisions before you tonight. There's the
Okay.
one associated with the grading in lot 5, which is to the south, and then the subject property we're talking about right now.
Any other questions from the board members? Hearing none, we'll open up the floor to any speakers in the audience who may want to speak in favor or opposition to this request.
Mr. Chair, if you'll give me a second. To all attendees, if you would like to comment on this particular request, if you would please use the raise hand feature. The department will recognize you and promote you to panelists so you can speak. Mr. Chair, I see no one with utilizing the raise hands feature, so I believe no one would like to comment on this particular request. Thank you.
All right, thank you, Director Unich. At this time, I'd like to offer the opportunity to hear an oral presentation of the department's report. Seeing none, would the Department of Planning like to make any final comments?
Yes, Mr. Chair, the department and members of the board, the Department of Planning is supporting this request this evening. The swap is acceptable to us. It's a land area that is equal in size, and given the new area is towards the back of the lot and will be less impacted by the development being proposed, we feel like it will have more of an ecological value in the long run. Additionally, our Department of Public Works has also reviewed this request, and they do not object to it. We simply ask that we keep these 2 issues concerning Lot 5 and the subject to lot we're discussing right now, which is Lot 6, separate in every way. So separate tree preservation plans, separate disturbance limits calculations, and separate grand tree identifications. And then, of course, and then all mitigation work is to be completed before any potential land transfers. Additionally, as usual with these types of requests, we are conditioning it on a revised deed and exhibit being presented to the department for review and acceptance before them being recorded by the St. Louis County Recorder of Deeds. Thank you.
Okay, thank you, Robin. At this opportunity, does any board members have any final comments they'd like to state? Hearing none, I've got one question for Director Unich of a formality. Should we proceed with a motion to approve or approve with conditions? Obviously, the conditions are kind of lengthy in this one. What is the proper way? Can we reference your recommendation report just to simply summarize it by saying the conditions would be that he follows the stipulations outlined in that document rather than having to repeat the 2? I mean, it's roughly 2 paragraphs.
Yes, Mr. Chair, you can simply say that the motion can be to support the department's recommendation with its conditions.
Okay. Perfect. Thank you for that. Hearing no other comments from the board, I'd like to close the proceeding for a vote. May I have a motion to approve, a motion to deny, or approve with conditions?
I'll make a motion to approve the report as presented by the Department of Planning.
So that's approved with the conditions?
Yes,
Okay. Do I have a second to approve with the conditions outlined by the department in their recommendation report?
I'll second.
All right. Thank you, Mr. Sprunger. Member Coleman, how do you vote?
Approve.
Member Sprunger?
Approve with the stated conditions.
Member Sides?
Approve.
Member Rubus?
approve.
And I approve as well with the with those following conditions. Congratulations, your variance has been approved.
Mr. Chair, to the two members, if you'll stay on the screen, we'll get to the next one right away. Mr. Chair, with your permission, I'll start the reading of the advertisement.
Please go
Second.
ahead.
Thank you. BA 0-22, Tim Klingler, 930 Wilderness Way Drive, Eureka, Missouri, 63025. Care of John Taylor, PO Box 127, Pacific, Missouri, 63069. Request an exception to the natural resource protection standards for the purpose of site preparation on the property located at 19030 Old Wild Turkey Lane, locator number 28Y 110075, Timbers at Fox Mountain Subdivision, Lot 5, which would thereby authorize relocation of the identified natural resource protection area as well as its associated 25-foot foundation setback area to accommodate it while maintaining the approximate amount of preservation area on the overall parcel of ground, i.e. an exchange between preservation and building areas. The site preparation is needed to accommodate garage addition referenced herein as BA 0-22. This request is contrary to the requirements of Chapter 420.200 Natural Resource Protection Standards and Procedures of the Subdivision and Development Regulations of the City of Wildwood Municipal Code as applied to the properties located in the NU Non-Urban Resident District and Chapter 415.090 NU Non-Urban Resident District Regulations of the City of Wildwood Zoning Ordinance. This particular property is located in Ward 6. And Mr. Chair, with your permission, before Ms. Keefe provides the slide presentation, the department would like to enter into the record the following items: the Charter of the City of Wildwood, Missouri, the Master Plan, updated in 2016 of the City of Wildwood, Missouri, Chapter 400, Article 2 of the City of Wildwood Municipal Code, the Board of Adjustment, Chapter 415 of the same City of Wildwood Municipal Code, the Zoning Ordinance, inclusive of Chapter 415.090 NU Non-Urban Resident District Regulations. The file that has been developed and maintained by the Department of Planning regarding this request and all contents contained therein, including the department's report with recommendation. And then finally, any testimony provided as part of tonight's hearing, including, but not limited to, any exhibits, maps, plats, photographs offered as evidence as part of tonight's proceedings. Thank you, sir.
All right, Mr. Chair, with your permission, I will go into my next presentation.
Please, thank you.
All right, members of the board, our next subject lot is the one south of the previous lot. It is abutting and it is in the same ownership. This lot is also densely wooded with an overall relief of 150 feet in this case. Again, the highest elevation is up near the cul-de-sac and then it slopes downward from there. Here I've depicted the work in question for this lot. Again, we're looking at that grading, which is within our natural resource protection area as depicted. It is also within the building setback, which has been determined acceptable by the Department of Public Works. In this case, we are swapping area C, natural protection area, with area D towards the back of that, what was previously part of the buildable area of lot 5. In this case, the size of that area is closer to 4,000 square feet. This is a westward, southwesterly view from the cul-de-sac. This is standing within what I believe is lot 5, looking out towards the cul-de-sac. So that's more of a northern view. Looking south, and here you can see lot 5 building site identified. And this is a westward view. And given that you have all the related information, I will conclude my presentation there. And if you have any questions, Director Vunich and I are here to answer them. Thank you.
Thank you, Robin. Mr. Klingler, this may be a little bit repetitive, but since this is a separate case, if you don't mind, we'll go ahead and just state your name, address, relation to the property, and then be sworn in a court reporter for this variance, please.
Yes, Tim Klingler, 930 Wilderness Way Drive, Eureka, Missouri, and I am the lot owner of lot 5.
Okay, Mr. Klingler, go ahead, and Courtney.
Please just raise your right hand. Do you solemnly swear that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, Mr. Klingler. Can you please explain the nature of this request and the hardship or practical difficulty necessitating the variance?
Yes, similar to the combination of lot 6 with lot 5, grading for a future owner and leveling the 2 properties out on the cul-de-sac for better aesthetics.
Anything else that you'd like to add, Mr. Klingler, and then we'll move to the board members?
No, I do not.
Yep, appreciate it. Thank you. Any board members have questions regarding this variance request?
Yes, Robin, as I understand it, the Department of Public Works has no problem with the grading on either lot.
That is correct. They even commented, our assistant city engineer commented when he came out to look at the site that he felt that it might even be better if this grading took place now versus in 2 separate occurrences, so one in the future.
Okay, so the issue really is we're swapping preservation area, like kind.
That is correct.
Okay, thank you.
Any other questions from the board members? Okay, seeing none. Any speakers in the audience who may want to speak in favor or opposition to this request?
And again, Mr. Chair, if anyone that's an attendee would like to speak on this particular matter, if you would please use the raise hand feature. The department will promote you as a panelist and you'll be able to speak. Thank you. Mr. Chair, again, no one's used the raised hand feature, so I believe we can proceed. Thank you.
Welcome. Thank you, Director Vunich. At this time, I'd like to offer the Department of Planning the opportunity to make any final comments. Or I'm sorry, the opportunity to hear an oral presentation of the department's report, if anybody would like that. Seeing none, now we'd like to offer the opportunity for any final comments from the Department of Planning.
So we are supporting this request as well for similar reasons. and with with the same conditions. Emphasis added on all required mitigation work is to be completed by the petitioner prior to any transfers of property.
Okay. Before we close the proceeding for a vote, any final opportunity for comments from the board? Seeing none, I'd like to close the proceeding for a vote. Can I get a call to a vote to approve, deny, or approve with conditions outlined in the department's report?
I'll make a motion to approve the variance request as documented in the recommendation report by the city.
Okay, thank you, Member Sprunger. Do I have a second?
I'll second.
All right, thank you, Mr. Rubus. So we have a motion to approve with the conditions outlined in the department's report. Member Coleman, how do you vote?
Approve.
Member Sprunger?
Approve.
Member Sides?
Approve.
Member Rubus?
Approve.
And I approve as well. Congratulations, this variance is approved as well.
Thank you.
Thank you, Mr. Klingler and Mr. Bichler.
Thank you.
Okay, Director of Units, are we ready to move to the next and I believe final case of the evening?
Yes, sir, Mr. Chair. Thank you. The final case tonight on the board's docket is BA 0-22 Kathleen O. Maxwell and Margaret H. Lewis, 190 Shiloh Oaks Drive, Wildwood, Missouri 63005, care of Caroline L. Hermingly, 190 Carondelet Avenue, Suite 600, Clayton, Missouri 63105. Requesting an exception to the minimum yard requirements general for the purpose of retaining an existing indoor riding arena structure at its present location upon the property located at 1901 Shiloh Oaks Drive, locator number 23X630052, Shiloh Oaks Farm, Lot 1, which would authorize a side yard setback of 31 feet in lieu of the 100-foot standard. This request is contrary to the requirements of Chapter 415.090 NU Non-Urban Resident District Regulations of the City of Wildwood zoning ordinance. This particular property is located in Ward 1. And again, before the department provides its slide presentation, Mr. Chair, would like to enter into the record the following items. The City of Wildwood Charter, the City of Wildwood's Master Plan, which was updated in 2016, Chapter 400, Article 2 of the City of Wildwood Municipal Code, the Board of Adjustment, Chapter 415 of the same City of Wildwood Municipal Code, the zoning ordinance, inclusive of Chapter 415.090 NU Non-Urban District Regulations. The file that has been developed and maintained by the Department of Planning and all contents contained therein, including the department's report with recommendation. And then finally, any testimony provided as part of tonight's hearing on this particular request, including but not limited to any exhibits, maps, plats, photographs, or other items offered as part of tonight's proceedings. And again, Mr. Chair, with your permission, the department will provide a very brief slide presentation at this time.
All noted, and thank you. Please proceed.
And my thanks to Ms. Keefe for helping out here.
Yes, thank you, Robin.
The first slide that the department's providing is an overall aerial photograph of the generalized location of the property. In this particular case, you can see the property is located in the upper left-hand corner of the aerial photograph. Key landmarks relative to this particular property is Route 100, which bisects the middle of the screen. And as you can see, the site is north of Route 100. Again, an aerial photograph of the particular property, in this case, very much just identifying the property that is subject of the request. As you can see, there is a single family dwelling located on it and other structures that are outbuildings. The date of this particular aerial photograph does not indicate the existing indoor riding arena. The next slide is an aerial photograph of the subject site, again, now with the topography overlaid from upon it. The topography is from St. Louis County records, and as you can see, there is some variability across the site. This particular slide represents the indoor riding arena and its location on the subject site. As you can see, there is the access roadway, the private street, the driveway that provides access into the lot, the existing dwelling, the other outbuildings, and again, the indoor riding arena is shown in by the highlighted yellow line. The next slides just kind of give a perspective of the site. This is the private street that provides access to the subject property. This is generally looking in an easterly direction. And this is the same private street now looking in the opposite direction or more toward the southwest. This is the existing single family dwelling located on the subject property. And this again is the subject property now looking in an easterly direction. You can see the horse stable to the right and the top of the indoor riding arena to the left. Again, this is more of a close-up of that general area, now looking more toward what I would consider the north or northeast. Again, the stable in the forefront, the arena to the background, and to the left of the slide, the nearest single-family dwelling. And again, this just gives a perspective looking directly to the east. In the background, you can see the Ameren, Missouri transmission easement. The towers are indicative of the easement location. Again, on the right-hand side of the screen is the arena, and to the left is the nearest single-family dwelling. And this just following the private streets to its terminus, which is a cul-de-sac further to the east. And this is looking across the neighboring property to the subject property. Again, just a similar visual photograph from the adjoining property to what I would call the south. And you can see the single family dwelling and the existing indoor riding arena. And this is near the cul-de-sac of the private street. And this is looking to the southwest. The Ameren, Missouri transmission easement is visible in the forefront of the slide. And then in the background, you can see the top of the indoor riding arena. Again, these are just some images of the indoor riding arena. This is what I would call the front, or that which faces into the subject property's interior. And this is on the eastern end of it. And Mr. Chair, that concludes the presentation of slides. Thank you for your all's attention.
Thank you, Director Munich. At this time, will the petitioner please come forward, state your name, address, relation to the property, and be sworn in by the court reporter?
And Mr. Chair, if you'll give me a second, I'll promote, I believe, the attorney that's representing the applicant. And if there's anyone else that needs to be promoted, if she would advise, I'd appreciate it. Oh, I guess they're all in the room.
Good evening. My name is Carrie Hermeling. I'm an attorney at Hush Blackwell, and I represent the owners, the petitioners. They are with me to my left. Mr. Chairman, would you like us all to be sworn in at the same time? Or I was planning on doing kind of just a quick question and answer and providing just a list of the exhibits that we've previously provided, just to kind of get that into the record. So how would you like me to proceed? I can do the.
If you could, why don't you each state your name, and then we'll, if it's okay with the city attorney, we will then swear you guys together, unless that's not acceptable.
So again, Carrie Hermeling, 190 Carondelet, Clayton, Missouri.
I'm Kathleen Maxwell, owner at 1901 Shiloh Oaks Drive in Wildwood, Missouri.
Margaret H. Lewis, owner at Shiloh 1901 Shiloh Oaks Drive.
Okay.
Okay, Mr. Chairman, in addition to the owners, we also have the contractor who built the arena, Chad Rupert, Ruppert.
Okay.
If you see him, Director Vunich, on the screen. And then the second outside witness would be Mr. Mike Kadish, the surveyor who was involved on this site.
Okay, we'll wait just a moment and see if Mr. Kadish comes on.
Mr. Chair, I believe I promoted both of them.
Yep. Okay. City Attorney Young, can we all swear in at once? Should we do it individually? Looking for a little guidance, if you don't mind.
As long as the court reporter is comfortable swearing everyone in at the same time, I have no objection.
I don't mind swearing them in, but when they speak, they need to identify themselves when they're switching back and forth speaking.
Okay. Fair enough, everybody.
And
Go ahead,
Mr. Chair, if I may offer a suggestion, if the contractor for the building as well as the other gentlemen are going to be witnesses tonight, could we go ahead and have them identify themselves and be sworn in at the same time?
Yeah, please, Mr. Rupert, can you introduce yourself and your relation to the property?
Chad Rupert. I live at 19104 East 15th Road, Witt, Illinois. I am a sales consultant for Morton Buildings.
Okay. And Mr. Kadish?
I'm Michael Kadich. I live at 3060 Kingsridge Manor Drive, St. Louis, Missouri. And I'm the field surveyor that came out and checked the grades and proposed new building locations.
Okay. Thank you, everyone. Courtney?
Okay. Please raise your right hand, everyone. Do you solemnly swear that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
Thank you.
Okay. At this time, will the petitioner or the petitioner's representatives please explain the nature of the request, the hardship and practical difficulty necessitating the variance as it relates to the character of the property only, please?
Yes, Mr. Chairman. And at this point, can I share my screen?
Please do. Robin, do they have the correct permission? Are they able to do that from a standpoint of the Zoom setup? There we are.
I believe so, sir.
Yep. Okay, thank you.
Great. So what you see before you is our petition for appeal of the zoning regulations. The condition under which requires this variance is the condition of the property itself, the existing topography, the drainage flow, the natural beauty of the property allows the indoor arena to be located in only one location, given the characteristics needed for an indoor arena, that it needs a flat area. There was an outdoor arena in its current location, and when there was a necessity for health reasons of Ms. Lewis to have an indoor arena, the issue was explored with the surveyor and the contractor on where the indoor arena could be located on the property. and the existing outdoor arena location was the only acceptable location in light of the existing topography. The nature of the hardship is that the owners spent over $230,000 to construct an indoor arena after they submitted the request for zoning approval to the city of Wildwood, which the city did approve on March 19th, 2019. Then the county of St. Louis also issued a building permit in connection with the project on March 25th, 2019. And the construction occurred, and the construction was completed then on around August of 2019, at which time all of the approvals and the condition was finally blessed with its location. It would be a substantial hardship to the owners to force a dismantling and removal from the sheer inability to put the arena anywhere else on their property, as well as the disruption to the existing site, as you all saw with the topography. At this time, what I'd like to do is introduce as additional pieces of evidence 25 exhibits, and I will simply go through them.
Please go ahead.
The first exhibit 1 on the petitioner's exhibit list is the City of Wildwood zoning code. I believe Director Vunich already introduced that, but that was one of our exhibits. Exhibit 2 is the City of Wildwood comprehensive plan. Again, Director Vunich introduced the master plan, which was updated in 2016. Exhibit 3 is the petition, which we just showed, and that was signed by both of the owners. Exhibit 4 is the permit that was issued by the City of Wildwood in connection with the arena. Exhibit 5 is the permit issued by St. Louis County in connection with the arena. And the next exhibits 7 through 9, give the board a review of the type of uses that people have used their properties in the neighborhood. This is a non-urban area, and the property is generally large lots, and people use those large lots for animals and in some cases a roller coaster and large outbuilding to house large trucks. Exhibit 10 is an aerial view of the property, of the one outdoor neighbor property. Exhibits 11 through 16 are property, which is the subject property, various views that will be discussed by the owners. Exhibit 17 is the St. Louis County parcel map, which has already been shown tonight. Exhibit 18 is a topographical map of the area, which is from St. Louis County, showing you how the topography flows at an angle toward the creek. Exhibit 19 is another topographical map. Exhibit 20 is the survey of the property that was done at the time the owners purchased the property. Exhibit 21 is a survey of the property showing where the proposed arena is located. And then exhibits 22 and 24, Mr. Kadich is going to be testifying to in connection with his survey work that he did, just to give you an example that if the zoning code was enforced in connection with the indoor arena, the location where this would have to go, and you can see the drop off of the topography, which would require that this arena could not be located on the property in light of the fact of the existing slope that exists on the backyard. And then exhibit 25 is Mr. Kadish's.
I'm sorry to interrupt, Mr. I want to make sure that your screen was not supposed to be moving because we're on 18 still.
Sorry. Sorry, I apologize.
Yeah, no, that's okay. I
Thank
just wanted
you.
to make sure you were aware.
No, thank you.
23, 25.
I'm sorry. So exhibits 22 through 24 show the sloping in the back, which really prevents the arena from being relocated. And then exhibit 25 is Mr. Kash's survey information in connection with the staking of his property. So with that, I'd like to bring forth my first witness. Unless I've got any questions, I'd like to move for admission into the record exhibits 1 through 25 at this time.
Please proceed.
Mr. Chair,
Mhm.
if you would accept the exhibits as presented.
Oh, yes. I apologize. Yes, those exhibits are accepted as presented. Any questions now, or do you want to continue? Ms. Hermanley?
I can certainly take questions now. What I'd like to do at this point is present just some brief testimony of Ms. Maxwell and Ms. Lewis, who are the owners. And then I was going to go directly into the testimony of the contractor, Mr. Chad Rupert. And I will end with the testimony of Mr. Kadish, who's the surveyor.
Please proceed. And then again, if you could, prior to each representative speaking, if you could just state your name to allow the court reporter to document that, that'd be helpful. Thank you.
Will do. Ms. Maxwell, can you please introduce yourself to the board?
I'm Kathleen Maxwell, the owner at 1901 Shiloh Oaks Drive in Wildwood.
And how are you connected with the property?
I'm the owner of the property with my mother.
I'd like to direct your attention to Exhibit 3 in the record and have you identify, is that your signature on the second page?
Yes.
And why are you here before the board?
We applied for the permits to build the arena, and the information that we received, through no intended fault, had us build the arena in the location that is not according to the ordinance as we understood it at the time. So it needs to be addressed.
So I'm going to have you describe for the board generally the neighborhood, if you could.
It is a neighborhood with large lots and beautiful, I know this will sound weird, but it actually has the most beautiful sunrises and sunsets ever.
In connection with your particular property, how do you use your property?
We have horses, and we ride our horses and train the horses on our property.
And in connection with Exhibit 7, can you describe for me whose property that is?
That is the Carpenters. They live on the other side of the neighbors that were in the pictures that you saw earlier.
And how is their property used?
They have a barn there that you could see. Their horses have passed away, but they had horses and they have a barn there.
And looking then at Exhibit 8, can you describe that neighbor?
That is the neighbor that has the roller coaster, and he has large buildings that he keeps very large fun vehicles in.
And so could you then describe what's in Exhibit 9?
Also his property. Those are some of the large fun vehicles and his part of his roller coaster.
Okay, referring to Exhibit 10, can you describe for the board what this picture depicts?
That is an aerial view of when you can see to the left of the barn is really what you kind of see there. But to the left is where the outdoor arena was before the indoor arena was built. So that shows that time frame where the outdoor arena was.
And why did you build the outdoor arena?
That was for working with the horses. And you need an arena to be able to ride and practice and train.
So I'd like you to look at exhibits 11 through 16 and walk the board through what those pictures are showing. And I apologize in advance for some of these that were scanned in the way they were. But looking at exhibit 11, what does that depict?
That's a scene from the street. You can see on the right side, the detached garage that goes with our home. And then straight ahead behind the trees is the barn where the horses are. And then to the left is the arena.
Looking at Exhibit 12, if you could describe what that photo depicts.
That is a picture taken at the property line, looking back toward our property.
Looking at Exhibit 13, please describe to the board what that depicts.
That's a view from our pasture on the west side looking east. And you see the end of the barn on the left, and you see the riding arena to the right. And you can see the tower with because there's an easement for the power lines back there.
Directing your attention to Exhibit 14.
That is from the back of our pasture, looking northeast and looking at that end of the arena.
Directing your attention to Exhibit 15. What view is that?
That is again from the street in the front of the home near the property line, looking at the end of the arena, which that faces north.
Directing your attention to Exhibit 16. What does that depict?
On the right-hand side, you see the corner of our arena, the tree that is on our property, and then the nearest home, the neighbor to the left.
Directing then your attention to Exhibit 22. If you could describe for the board what that is intended to depict.
That is a photograph from the painted post at the bottom there. It would be if the arena were to move the 67 feet in, that's where the corner you see at the top of the hill would be at the bottom of the hill, and the other corner would still be at the top of the hill. That makes sense.
And then looking at Exhibit 23, what does that depict?
That is a picture from another angle to get you a better view of what that slope really looks like. So that's about halfway down the slope, because then 24 takes you all the way down the slope into the trees where the creek is, and the runoff goes down through our trees. That's the only woods that we have on the property there, and the creek runs through it.
And then finally, looking at Exhibit 24, could you describe what that picture depicts?
I kind of jumped there. Sorry. That was to the trees and the woods and the creek.
So are you familiar with the property?
Yes.
And would you agree that the photos that are depicted on Exhibits 11 through 16 and then Exhibits 22 through 24, that those are accurate depictions of your property?
Yes.
And then in connection with your familiarity with the neighborhood, you're familiar with the neighborhood?
Yes.
And would you agree that the depictions of the photos in Exhibits 7 through 9 are accurate depictions of some of the conditions in your neighborhood?
Yes.
So for purposes of the proceeding that we're here, what are the practical difficulties with the existing condition of your property, which required the location of the arena at its current location?
In order to have an arena to work in, it has to be flat, and it has to be near electricity and water. You have to water the surface inside. And so it has to be in a place where it can be flat. I mean, I know I said that, but that's kind of the most important part.
So when you entertain the process of building the horse indoor arena, excuse this, can you actually excuse me for 1 second? Katie? Oh, I guess we can just proceed.
We just keep talking.
Yep, I know. I wasn't expecting that. 1 second, excuse me. Here we go. Okay. So in connection with the process to build the horse arena, can you walk the board through got this approved.
When my mom became the co-owner with me on the property and told me that she needed an indoor arena because of her autoimmune problem, we reached out to the city of Wildwood. Well, I did. I called first because I didn't know what we could or couldn't do. So I spoke to Steve Vogel and I asked, what does one do when you want to build an arena? And so he asked me the size of the property and he did a calculation of how big the building could be. And he asked me what would the use of the building be. And he was very specific about the use of it because he said it couldn't be a stable. And I said, that's fine because we already have a stable. And he said, okay, it can be actually larger than what we ended up with. He said it could be as big as 10,890 square feet because of the size of the lot and that the setback would be 30 feet. So I went back and we contacted a couple of contractors. We contracted Wick and then we contracted Morton, and Chad and I actually went to the city of Wildwood and got the parameters. And so then we built, he created the proposed site that you saw earlier, and we submitted that to Wildwood and we got the approvals and we built, and then we were approved after that.
Great. So at this time, I'd like to present Ms. Lewis, her testimony. Ms. Lewis, could you please introduce yourself to the board?
I'm Margaret Lewis, and I'm the co-owner of Margaret Lewis, and I am the co-owner with my daughter of the ranch. And
again, on the petition for the variance on the second page, that's your signature on Exhibit 3, is that correct?
Correct.
And why are you here before the board?
I'm here because it's a beautiful arena, and it's kind of my fault that it got built, but I had horses, and my mom and I had ridden for 29 years at a boarding ranch that had an indoor arena. Mom rode until she was 92. She died when she was 93 years old. And I knew that if I kept riding, I might have her longevity, which is what I really wanted to do, and that my daughter and I could keep on riding. But I have Raynaud's syndrome, and so I cannot be out in cold weather. And I'm in my 70s, and I really, I get cold. I really get cold. So I knew I had to have an indoor arena. And I knew my daughter really likes the outdoor arena, but there was only one place to put it. And so we built the best arena we could possibly build. And we put 3 cupolas on the top and really nice windows and special trim. And we did everything we could to make it look as beautiful as possible, because Wildwood is beautiful and we wanted something that would really fit in. And it was so disappointing when we found out that it wasn't in the right place, because we had no idea. So that's why I'm here to talk about. It's a beautiful arena and it needs to stay where it is. It's just impossible to move it.
Ms. Lewis, if you could describe how often you use the arena.
I've been riding 6 days a week, and when we can't ride, we train. I had a young gelding who was really kind of wild, and I really needed to work him a lot. And so we were in there all the time. He ended up dying, but now we have other horses that we work with. And so we're in there all the time.
So when you entertained the construction of the arena, can you walk the board through what issues you dealt with so that there would be no issues in connection with sacrificing trees, preserving drainage?
No trees at all, because we built it right where the outdoor arena was, which was the only spot. That was the flattest area. We had to do a lot of grading, and we had to do a lot of work. We wanted to make sure that nothing would get on our neighbor's property. And so we had extra grading done, which cost a lot of other money too. But we graded it and then we checked it out, and then it would rain, and then we would get them out again and we graded it again so that it would run down. And then we put a lot of things, down below so that it would go the proper way. And then we paid, I forgot to put that, we paid like $5,000 for hydro seeding to seed the whole thing so that we could get stuff growing on it. And just did everything possible to make this work out for everybody concerned.
Could you break down for the board the costs associated with the construction of the arena?
Well, the arena itself was $198,271. And the footing, the special footing for the horses, plus the grading, was $25,966.
And who was the contractor who did that work for you?
Kelp, Wildwood, Kelp Construction, a Wildwood construction company. And then Chesterfield fence, we had to have work done at the corner. So we had some fencing done. So the horses couldn't fall into the area because there's a slope there. And then Premier Equestrian rubber for the footing was $4,900. And then a retaining wall and a wall on the other side to work with water, make sure everything ran correctly, $3,525. A total of $233,649.10, not including the hydro seeding. So,
and again, you're familiar with the property?
Yes.
Are the pictures that we introduced as a part of the record, are those accurately reflecting the condition of the property?
Absolutely.
What are the practical difficulties with this particular site in trying to put the arena anywhere else?
We considered all the other areas. There was nowhere else to put it. This was it.
Is the pasture area level or is it rolling?
It's all sloping.
And this location, was it close to the electrical and the water that you needed?
This is the only one that was near the water and near the electric.
In connection with investigating any costs associated with trying to relocate it if you could, do you have estimates of what those would be?
Our best estimate would be somewhere in the neighborhood of $500,000 with all the grading necessary and the care that you'd have to use in taking anything like that down and then attempting to put it back up with all new footing and everything involved. It would be practically impossible.
Would there be other issues in impacting the overall topography and of the area?
Well, I'm afraid that if it were moved any farther down, even if it could be done, all of the water would then run off and go into a small pond and onto the neighboring property down below, and that would wreck our neighbors. It would be a disaster.
So at this time, I'd like to bring forth Mr. Rupert. Mr. Rupert, can you please introduce yourself to the board?
Yes, Chad Rupert.
And what's your
1904 East 52.
Excuse me.
Yes, I'm a sales consultant with Morton Buildings.
How long have you been a consultant for Morton Buildings?
16, 17 years.
Are you familiar with the property at 1901 Shiloh Oaks Drive?
Yes, I am.
And how did you play a role in connection with the construction of the arena?
Like Miss Maxwell and Miss Lewis said, they contacted me in need of an arena, and so as part of the consulting phase of it, went down there and spoke with them and found out what they're looking to do and worked with them through the process.
So looking at Exhibit 4B, which is on the screen, can you identify, is that the March 19th, 2019 approval of the City of Wildwood for the proposed arena?
That is.
And then looking at Exhibit 5, is that the permit from the city, from St. Louis County in connection with the construction of the arena?
Yes, it is.
And then looking to Exhibit 6, are you familiar with the inspections that were done in connection with the construction of the arena during 2019 when it was being built?
I am. I called in most of them.
Then in connection with the topography of the site, when you were approached to build the indoor arena, did you look at alternate locations on the site?
It's the first thing we do. One of the first things we do as a sales consultant is the location of the building. That's obviously the most important thing after determining the needs of the building and what the owner needs out of it, and getting the size narrowed down. Next step is to find a location to sit the building. Went out there with Miss Maxwell and Miss Lewis. We walked the property, and well, number one, the electrical easements. There's the big ones to the back, and then if you notice by the stable, there's a electric line that goes by there also, which has its own easement. The creek that runs through the middle of the property, it's extremely rolling getting down to that. There's really no way to cross that creek to try and get something on the other side. It'd be about impossible. The existing outdoor arena was there, and that was the only place that we could stake out and make work for our building. Our building, we're a post frame type construction building. We're using concrete pillars in the ground. We only dig them about 6 to 8 feet, about as deep as we can do these type of foundations. And we want to get down to virgin soil to set them footings. You'll notice on the pictures of the arena, you notice the slope that came off of there. We had to build up. We took some dirt from the bottom, pushed it up there to level that up. One thing you'll also notice on that arena, the north end of that arena is actually buried 3 foot in the ground. That was one of the other things we came up with to try and that's how unlevel the whole site was. I actually had to recess part of this building 3 foot underground in order to get the necessary square footage for the flat indoor arena.
So in connection with Exhibit 19, does that accurately reflect the topography that you were dealing with in determining where to locate the arena?
Yeah, the topography was one of the biggest challenges with this project, other than the rain while we were building it. They'll both remember that. I think it rained 30 inches in 30 days while we were trying to build this. But yeah, the unique configuration of this lot, as mentioned, the topography has its own. When you come from my side of things, looking at, I built a lot of buildings, and it's pretty easy to figure out where you're going to put one, and it's pretty easy to figure out where you can't put one. And this was where that existing outdoor arena was the only location to build this.
So thank you. Now turning to the testimony of Mr. Kadish. Mr. Kadish, can you please introduce yourself to the board?
Michael Kadish. I'm a field surveyor.
And in connection with field surveying, how many years have you been doing that?
Approximately 20.
Are you familiar with the property located at 1901 Shiloh Oaks Drive?
Yes, I am.
And in connection with that topography, did you undertake some surveying work in connection with the attempt to try to locate a new location for the arena on this property?
Yes, Miss Maxwell approached me and asked if I could come out and give her an idea where the building would be located if it were in fact moved 67 feet more to the southwest.
And
that's what I went out for.
And looking at Exhibit 19, looking at Exhibit 19 and Exhibit 18 and Exhibit 20, are those documents which you looked at in connection with assessing and determining, the topography and the characteristics, size, and shape of the property?
Yes, I'm familiar with those.
In connection with the topography that's reflected on Exhibit 19, how would you describe that topography?
I would say it's quite sloped from the arena down towards the drainage area, which is clearly by that topography where most, if not all, of the property drains to. And it looks to be quite steep, as you can see in the other exhibits where I located elevations. My elevations were pretty similar, if not extremely close to the ones that are on the topography map as well.
So in looking at Exhibit 22, 23, and 24, did you stake the stakes in the locations as depicted on those photographs?
Yes. Would you like for me to go into a little bit of detail of how I located them?
Sure.
So I used my global positioning system receiver, the GPS receiver, and I located the four corners of the existing structure. And then I was able to calculate 67 feet along those property lines, basically the east, or along those building lines, the east edge of the building and the west edge of the building. And I was able to project those out to where the proposed new building corner would land. If you're looking on Exhibit 24, the farthest stick that you see almost into the woods where the drainage area is would be the proposed southeast corner of the structure if it were to move the 67 feet that's being asked. And I also did the same on the west end with the other, where you'll see the other stakes there too.
And are your results of your measurements reflected and summarized on Exhibit 25?
Yes, the existing grades, the finished grades that are there are also located on the sticks. They're labeled exactly what the finished grade is at each one of the lads that I put in the ground, which are consistent with the information on the paper.
In your experience as a surveyor, what is the effect of the topography or the land's unique character on the prospective construction of an indoor arena on the property?
I would say that it's not possible, not easily possible, or even practical to place it anywhere else other than where it is. If you were to move it, the amount of dirt that would have to be put down there to actually move the arena would be quite a bit. And not only would it be impractical to do that, it would also disrupt the flow of the property as far as getting all the drainage and the water down. So I can't see any other place where it would make sense to put it myself, in my opinion.
At this point, Mr. Chairman, I'd like to open up for questions for any of these witnesses for the board.
Mr. Chairman, could I state one more thing? This is Chad Rupert with Morton Buildings. I just wanted to piggyback on what Ms. Lewis was talking about, the moving costs or trying to move this thing 67 feet, what it would take to do it. And she mentioned upwards of $500,000, and that is what it'll take to try and move this thing. It's absolutely impractical to move this building. You'd be better off burning it down than trying to move it.
Mr. Chairman, at this point, I'd like to open it up for questions from the board, unless you have another thought on process.
No, absolutely. I will do that. I do have, while you're on that slide, I'll get started with a question. So if the petitioner's team could explain, you've got two stakes there, obviously one on the corner of the existing building. As you come down the hill to the right, you've got another stake. What does that remind me again what that stake is displaying?
Okay. The one,
And
the one closest
before
to the
you,
building.
Mr. Kadish, Mr. Kadish,
Uh-huh.
just because for the court reporter, if you could identify yourself
Oh.
before you speak.
Sure.
Thank you.
Sorry, this is Michael Kadich, the surveyor. I'll explain. The lab that's closest to the building corner is just to give you an idea of what the elevation is there, and it's written on the stick. The one at the bottom of the slope is a point on the line of the new building, proposed new building. It is not the corner. It is just a point that would be along the line. And I've put another elevation there to show another the difference in the elevation drop there. And you can't see it on this picture, but actually farther to the right is where the actual proposed corner would land.
Is it safe to say that the roof height would need to be roughly the same in that location? Obviously, drop down into that valley there, you'd have all kind of drainage problems. So would the new roof be basically the same height? You'd have to build that up to about the same elevation? I guess that may be from Mr. Rupert.
Yes, Chad Rupert with Morton Buildings. Yes, the elevation, the final grade elevation of where the current arena sits would need to be maintained, mostly due to the access coming in off the stable, the roadways that comes in there. That's the only way you would be able to have access, by lowering the building, the elevation of the building. It would eliminate your access point to the building.
Correct. So it's fair to say that you would not gain any relief from towering above the elevation by moving it. It's going to be roughly the ceiling, the roof pitch is going to be the same height. Basically, you're
correct.
moving.
The
Okay.
peak heights would be relatively the same with the shifting of the building, so to speak.
Perfect. Thank you, Mr. Rupert. Any board members have any initial questions for the petitioner's team? And because we're sharing the screen, it's a little difficult for me to say. So if you guys don't mind, just kind of just go ahead and announce, and it's hard for me to see your hands.
Jared, this is Arnie Sprunger. I actually do have several questions, and I'm not sure if I'll be able to address specifically which person maybe to answer it. I'll just refer to Team Maxwell. How's that? So my first question is, and again, I have several. The first question is, did the petitioner know of the setback requirements before they obtained approval from the city?
Sorry, Kathleen Maxwell. When I called Steve Vogel, he stated that the setback was 30 feet. So that was the information that we went off of. And when Chad was actually, or Mr. Rupert was actually helping to draw up the plan, he suggested that we could be as much as 31 feet away and still make that work. So we went with 31 feet. So it wasn't until much later, like a year or so or more later, that it came to our attention that it was not in the right place, because the people in the city of Wildwood that were helping us didn't realize that it was in the wrong place.
Okay, so I thought I remember you saying that earlier, that you got that information from Mr. Vogel. Okay, thank you. So I know it's always hard to do this, but I'm going to ask the question. If Mr. Vogel at that time would have said, well, you see, because of the size of your arena, you are going to have to have a 100-foot setback. What would have you done at that point?
Well, we would have approached the Board of Adjustment like we are now and asked for a variance to put it where it is now, because that's the only place that it can go.
And again, that was Mrs. Maxwell.
Oh, sorry.
Okay, so you would have do what we're doing right now. Okay, so let me ask another question then. I know you keep talking about there's no other place that you could have put the arena. But yet I also heard you talking about, well, if we move the arena, it costs us $500,000 to do that. So I guess I'm a little confused that you say that there's no other place that you could put it, but yet on the other hand, you're saying, but if we did move it, it would cost $500,000. So is this a matter of, no, we couldn't physically move it? Or is it a matter of, it would just be cost prohibitive? We could move it, but it would be cost prohibitive. I'm trying to understand which of those two it really is.
Again, this is Kathleen Maxwell. It's both. Primarily, it is that it wouldn't work, but we also wanted to illustrate that the cost involved would be astronomical and it wouldn't work. So we hypothetically gave a cost on what it would cost, but it's not doable. So both of those apply.
Okay, so I'm sorry, I don't have all the names completely written down. I think it's Carrie. Are you the person? You're the person representing the Maxwells, right?
Yeah, I just.
Okay, I'm sorry. I would address you by your last name, but I don't know. I don't remember what it is. But would you mind bringing up on the screen exhibit number? I think it's 19.
Scroll down. I scroll down on your screen. I know. I think you're muted. Or.
Oh, I'm sorry. You're right. Yeah. Would you mind moving it down just a whisker so we see pretty much the entire picture instead of, there you go. Okay. Thank you. Thank you for doing that. Okay. So when I look at this land, I'm just trying to understand why there wouldn't be another location. And because I look at the topography, and when I look at the topography, the top of the arena is almost at the 796 line, and the bottom of the arena would be at the 788 line. So that's not quite an 8-foot drop in elevation, if I'm reading the topography correctly. Okay. And I understand the notion that the further you move it to the west or slightly southwest, assuming up is north, you're gonna move closer to that creek area or the ravine, probably more like a ravine, really. You're gonna move closer to that, and I understand, it just gets harder when you do that. What I don't understand is if I look on the west side of the woods, and I see an elevation line of 800 feet. And then I see the next elevation line. I think each of the elevation lines represents a 4-foot drop. And I look at that and I say, wow, that's even flatter than where it is right now. So I guess I don't quite understand why that wouldn't have been a build possibility. I just don't quite get that. Because I think your argument, your basic premise here is that there's just no other place where we could put it. And I just don't quite understand that looking at the topography of your property.
And on who was Chad, Mr. Rupert, do you want to take that? Because
I'm talking a little bit.
I think there's several factors that factor into the arena being where it is.
This is Chad Rupert speaking. You can't see one of the smaller power lines. It kind of goes through there, so that kind of eliminates that one corner. And if you do that 100-foot setback or whatever we're going to have, by the time, your 800 looks flat there on that west side. But the time you move over the required 100 feet, and then the time the end of the arena gets out there, you start getting on them really tight elevation lines, and you can't build it up enough to outrun them elevation lines over there. And then you start talking about access. You would have to I mean, whether you say cost prohibitive or whatever, yeah, you could build some type of bridge across the creek ravine there, and route new power out there, route new water. Sure, anything can be done for $1 million, but it's absolutely cost prohibitive to put anything on that side of the property.
So are you saying, Mr. Rupert, that because when I look at the elevation lines, and I'm not trying to debate with you, I'm just trying to understand.
Yes,
when I
whenever.
so when I look at the elevation lines, it's interesting because let's see, 800 less. Okay, so the 796 line, okay, the 796 line looks like it sort of wraps around, and it looks like you wouldn't be going down through any kind of ravine if you went that way from an access perspective, from the house or from the road or whatever.
I follow
you.
you.
See what I'm saying? You see what I'm saying?
I see what you're saying based on this overview elevation map, but I'm telling you, as the real world and walking through there, it does not look anything as flat as this map is indicating. And so that's a little bit deceiving. I see completely what you're saying. But I'm telling you, in real life, that's not how it shapes up.
Okay, so are you thinking maybe the elevation map is incorrect?
I'm saying that could be possibly washed out further from when this elevation map was developed.
Okay, so just to be clear, are you saying that? And again, I hate to use these really wild numbers, but say $1 billion. It's so crazy that it's just that you could do it, but it would just be very, very expensive. Is that the real answer? Or is it that no, you really couldn't because the thing would like tumble down into the ravine? Or, I mean, I'm just trying to really get my arms around that.
Well, I know, and that's a fine line. I can hitch up with Elon Musk and fly to the moon if I had the money, but it's not practical. So yes, from how this sits, if resources are unlimited, you could build a retaining wall, and there's a lot of things you can do. But again, they're going to take hundreds of thousands of dollars, which would have been cost prohibitive to the project.
Sure. Yeah, that would have been maybe the difficulty there was. Yeah. Okay.
While developing for the location to put this, you went through with the necessary protocols and spoke with the city officials, and we were all under the understanding, through no fault of anybody's, that is where they could be put, and therefore the arena was designed and set in the only possible location.
Thank you.
Struggled building it where it was at, actually, because we couldn't hardly get a crane to sit. Obviously, there was no room on the east side to set the crane, and on the west side, where it gets falling off so bad, we had a really tough time getting a spot because the crane's down lower and getting them a flat spot in order to get the trusses set. And physically, we couldn't have. Without a major crossway, we couldn't have got the building materials to the west side of the property.
Okay, so, and this will be, I think, probably my last question, unless I have another one. If you would have known it was 100-foot setback, you would have come before the Board of Adjustment. If the Board of Adjustment would have said, no, that you were just not going to let that go, you just wouldn't have been able to build one. Is that what I'm hearing the petitioner say?
Well, on that basis, we would appeal that, obviously, because of the existing topography of the property and the existing creek and the existing utility lines and the lack of access, et cetera. So, we certainly wouldn't build it until there was approval, and there was approval in this case, so we built it.
No, I understand that. I'm just trying to get my head wrapped around what that would have meant to you practically if you wouldn't have gotten your approval. You you wouldn't have considered any other options. You would have just said, darn, we're just not going to be able to build this thing. I'm sorry, I was just trying to ask that question. If you weren't able to get approval to get a variance, are you saying that there's just no way you would have been able, or you would have chosen not to build on any other location?
This is Chad Rupert, and as a contractor, I probably would have walked away from it because there's no way we could have built anything in any other location. As far as Miss Maxwell, Miss Lewis, I mean, I don't know what they would have done, but if it was me, I would change properties, find a different place.
So Miss Maxwell and Miss Lewis, is that what you would have done?
I don't know what we would have done. We went to the city of Wildwood and asked what we could do, and they told us what we could do, and that worked, and we did it. I don't know what we would have done.
Okay, thank you. Thank you. I just wanted to push on this a little bit just to see, you know, because a real important component of this issue is viability of building location. And so I apologize if I'm pushing as hard as I am on that question, but it really is kind of central and core to the decision that you're asking the board to make. So thank you for indulging me to ask those questions.
Thank you. It's important.
Runger, any other questions from the board?
Yeah, Jared, Jim.
Yep, go ahead, Ms. Rubis.
In this whole process, I guess I'm addressing this to Miss Lewis and Miss Maxwell. At any time during this process, did you share your plans with any of the neighbors?
What plans do you mean?
To build this outdoor arena, did you share that with your neighbors, saying, just kind of want to let you know we're going to be building this arena and here's where it's going to be?
I don't remember talking about it.
But you did have conversations with your neighbors concerning the arena.
About the,
But he's saying to,
he
Are you
said,
saying-
did we mention it before we built it?
I don't know.
Did you
I don't
share
know.
I'm
your-
not sure.
did you
I don't know what the
share
question
your
is, but I know you
plans?
had conversations with the Swishers, you know, so certainly.
This is
Carl
Chad
came
Rupert
over to
again.
my house and
I
asked me about it.
Yes, and I spoke with him. He flagged me down, just wondering what was going on. I spoke to him about this at one time before any of this was constructed also.
You also talked about a lot of grading. How much grading did you have to do?
I don't know if you can answer that. That might be a Chad Rupert question.
We did.
Well, yeah.
There's a couple days of excavation, bringing up some dirt. We took out a little bit of the hillside to the south of there towards them power lines, brought it up until the finished level off the site. Most of the grading was done for that outdoor arena prior to this indoor arena. You'll see that on this aerial, you see that the square that's there. But we had a crawler dozer on site for weeks. As I mentioned before, it rained a bunch while this was happening, and we wanted to be careful as to not direct any of the water. All the water needed to go where it went before. So that was part of our grading efforts to there's a pond down there to the south also. Try to be extremely careful as to not push any sediment into that pond there. So yeah, there's several days worth of grading involved.
And in conjunction with this grading, did you pull a grading permit from the city?
No, we did not have a grading. We talked with
It's
Mr.
part of what
Vogel.
was approved.
Yeah, it was part, there was part of it. He
Grading
had
was on the
elevation.
approval. Mhm.
Sorry, everyone's talking at the same time, but I know the grading permit was a part of the initial approval for the city.
Mhm.
So compared to moving the building the 67 feet, how much grading would have to be done?
This is Chad Rupert on the contractor
Yeah.
side. I'm not sure where we would get the dirt from. There's no place to steal the dirt in order to build a level elevation to situate that existing 72 by 140 indoor arena. There's, without digging a major hole or a new pond or something, that we would have to bring in fill from somewhere, which is going to cause a lot of road traffic there, and it's a lot of cost. And you're looking at, I'm thinking it's going to take several thousand ton of dirt, and you're looking at it's going to be over 10,000 ton of dirt to fill that up, to move it over 67 feet to create. It's not so much the building itself, it's the surrounding grade. The further it goes to the west or to the south of any direction, it just accelerates the drop off. You notice the lines get tighter as they get closer to that creek. And for each foot of additional fill, you got 5 more feet going out to try to so it's a navigable slope coming off of it.
I mean, you've seen the property. I haven't. It's 12 acres, correct?
Just under.
Yeah. There's not enough fill on the 12 acres to do that.
Not without messing up the neighbors.
Do that.
Okay. And the answer to my first question is and this is addressed to Miss Maxwell and Miss Lewis, you did or did not share the plans with the neighbors?
We did not show our actual plans to the neighbors.
In other words, what I'm getting to is did the neighbors have any idea where this building, the structure was actually going to be constructed?
As soon as the dirt began to be moved, Mr. Swisher came over and came into my home and inquired what was happening. So I let him know everything that was happening, the purpose, the size, the everything.
So that the first time that he became involved in this?
At the very beginning, yeah.
Okay.
Anything else, Mr. Rubis?
No, that's it.
Okay. Any other questions from the board members?
I have a question.
Go ahead, Ms. Coleman.
Oh, okay. This is for Miss Maxwell or Miss Lewis. How long before the arena was built and you had an outdoor arena, how long was that arena there?
This is Kathleen Maxwell. The outdoor arena was constructed in January of 2018.
Okay. And so you started the building like in 2019, correct?
The actual construction, yes, was in 2019.
Okay, so my question is so you had an outdoor arena for approximately 1 year. Were there any complaints at that time by your neighbor that you had an outdoor arena? Was that okay with your neighbors? Was not an issue?
Right, there were no complaints.
So he did not have an issue with that. Okay. So possibly maybe he was maybe upset that he wasn't approached before the whole thing began, you know, as a neighborly thing. You say, oh, I'm going to do this, or so he really had no idea until people started showing up.
Is that are you asking a question?
Yes, ma'am. That is a question.
Sorry.
No one had really gone to him and ahead of time and said, this is what we're doing. He really wasn't told until work people started showing up. Is that the impression I'm getting? That's a question.
I'm answering. I didn't talk with him about building my round pen, and I didn't talk with him about building my outdoor arena.
Mm-hmm. Okay, thank you.
So I have another question just based on this discussion here. If I remember correctly, Mr. Darn it, Rupert, no, the Morton guy, Chad, yeah.
Yes, sir.
It looked like, I mean, it looks like you put the building basically on top of where the outdoor riding area is. Is that correct?
That is correct.
Okay, all right. So certainly it was convenient. You said that there was a fair amount of grading that had to happen to get that area flat. Is that correct?
The outdoor arena was not level. It was flat, but it followed more of the terrain that was there previously.
Okay, so the outdoor arena, and you may or may not even know this, maybe Ms. Maxwell does, but did you have to do any grading or anything to make the outdoor arena work?
Yes, there was grading done for the outdoor arena. I would say probably about 4 foot, probably 4 to from just remembering when I was out there visiting the site, it fell off of the backside, the south side of that arena, probably 4+ feet. I know, and again, it sloped. It probably had a foot of fall within that outdoor arena.
Yeah, just by looking at it, I would have guessed it would have been at least 4, maybe as much as 6 feet of
somewhere in there. Correct.
Yeah. That looks like it makes perfect sense. And I'm not familiar with this. Maybe the city could answer this, but were you required to get a permit to actually put that in, or a grading permit to do that?
This is Kathleen Maxwell. No, we were not.
You weren't required to get a grading permit or anything for that?
No.
Okay, thank you.
Any other questions from the board?
Yeah, I have one.
Go ahead, Mr. Tides.
If you look at Exhibit 16, yeah, that one. Is that the Swisher's house that we're looking at?
Yes.
And this question is for anybody that knows. Does anybody know the distance between that house and the barn? Just for perspective.
I don't.
What would the surveyor, the construction guy, would they have a guess? A good
I would
guess?
say the neighborhood of 200 feet.
Okay.
250, somewhere in there. The arena itself is 72 wide. You're just seeing a portion of it on the right hand of the screen there. Kind of go with them fence panels. They're 8 foot, but it's somewhere between 200 and 250 feet, just as a guess.
So if that's true, then those buildings are the exact distance apart that they would be if they both had a 100-foot setback. I'm just.
That would be correct.
Yes, okay. That's my only question. Thank you.
Okay, any other questions from the board members before we open it up to the audience? All set? Okay, at this time, I'd like to open the floor to any speakers in the audience who may want to speak in favor or opposition to the request.
So, Mr. Chair, with your permission, first I'd ask Ms. Hermeling, given that we're getting public comment, would you mind stop sharing your screen so we could?
Yes, I was just going to ask that question. And just for the record,
You just cut out, Ms. Herman.
apologize. Just for purposes of the record, the person that was addressing the distance between the Swisher's house and the arena was Mr. Rupert. And at this time, I will stop sharing my screen.
Thank you, ma'am.
Okay.
Mr. Chair, we have 3 individuals with their hands raised. I'm going to start promoting the first one.
Thank you.
Mr. Swisher should be coming on screen.
Are you there, Mr. Swisher?
Yeah, I guess my camera is not working. Would that be start video?
Yeah, you would be correct.
Is it possible to have my my lawyer join me at the same time?
Yes, Mr. Swisher, could you give me the name?
Eric Zaremski.
All right, thank you.
So while he's coming in, Mr. Swisher, could you please introduce yourself, name, address, and relation to the property, and then be sworn in for the court reporter, please?
Yeah, my name's Carl J. Swisher, and I have the property adjacent to 1901 Shiloh Oaks Drive, and that address is 1919 Shiloh Oaks Drive.
Okay. And I've got to keep everybody's screen. Courtney, are you ready?
I'm ready.
Please
Please raise your right hand. And do you solemnly swear that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
Absolutely.
Thank you.
Okay. Did you want to get started, Mr. Swisher? Or would you like us to swear your attorney in and then you guys kind of chat back and forth, or how do you like to go about this?
Eric, would you like to do an introduction?
Sure, if I may, if I need to be sworn in first.
Yeah, please introduce yourself, name, address, relationship to the property, and then be sworn in, please.
I am Eric Zaremski. My address is 4509 Lime Ferry Road, St. Louis, Missouri, 63129. I'm an attorney with TDD Attorneys at Law.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Hey, gentlemen.
Thank you. And just to give a bit of additional background on this, construction had begun in 2019, at which point when we kind of were aware of what this building's footprint was going to be, what the elevation was going to look like, how that was going to, visually at least impact, in addition to the additional grading, impact the Swisher's property. We did bring a lawsuit in the Circuit Court of St. Louis County that's currently pending before Judge Stanley Wallach. The city of Wildwood, and as I'm sure this board is already well aware, has been involved in that lawsuit as a party. They are no longer involved in the lawsuit, but we are seeking an injunction to have the property torn down. Now, there's been a lot of discussion about where this property could, or where the structure could be located. If it were relocated, what the cost of that would have been or might be. The fact of the matter is, the way this has impacted the neighboring property, the failure to proceed with obtaining the proper variance at the outset, the lack of any sort of ability for public comment, particularly from the Swishers who have been impacted by this structure. I don't think those things were. I think it was a wholesale failure of due process in this matter, and so. I just wanted to make sure the board was aware of that, and we were mindful that there is this lawsuit ongoing. In addition to that, I will have some exhibits that I'd like to present, just a series of photographs. But if I may, I'm not exactly tech savvy as to how to share screen. If someone with a bit more acumen than I.
First, make sure you have the proper credentials. Robin, is he able to screen share at this moment?
I believe he should be able to if the petitioner was able to.
Okay, so you should see several participants chat, share screen. If you use the share screen option, it should, and you click on the file.
Okay, so if I could put my last exhibit first, this is actually my exhibit 4 is a copy of the MLS listing for 1901 Shiloh Oaks Drive. This shows a listing, at least the listing as of 2/16. We see the original sale price was $1.2 million. They're now listing for $1,050,000. This listing went up on January 1st of 2022. And second page information on this detail report is that we now have a pending contract subject to financing, subject to inspection. It appears that it went under contract on 2/1. So in discussing potential relocation of this property, in discussing the potential cost to Ms. Maxwell and Ms. Lewis, it's pretty clear their intent is not to continue using the riding arena. Their intent is to sell. And, I think it is that is motivating them approaching the board now, because I think they wouldn't be able to sell over, number one, over the lawsuit, but number two, this zoning violation. I think a title company and a surveyor would come out, take a look, and say, no, this isn't okay. This needs to be fixed before they can sell anything. So they're not, they're not in this to continue their use. They're in this to get out of it. Moving on to my photograph exhibits. Exhibit 1 were a series of photographs taken in August of 2019. It shows, now granted, there is grass in this sort of muddy area now, but this is illustrative of the type of water discharge that is really the crux of the lawsuit that we filed. Coming off of the side of this building onto the Swisher property. As you can see, this is running directly into the Swisher septic field. It is a substantial amount of water discharge that comes off of the side of this building with the additional grading. This is damage that was left after the property had dried up, just sort of damage to the septic field. Now my exhibit 2, series of photos that was taken in April of 2021, and it shows now, of course, the grass has grown in, but you can see after a period of rain, we have the same problem. We have a significant water discharge coming onto the property. Now these are the photographs, my exhibit 3, of the sort of progress of this. And this is a view from the Swisher's home facing the area, I believe would be where the outdoor riding arena was.
Yes, Eric, the outdoor riding arena would have been in place at the time of this picture.
Yeah.
Correct. Yes, that is my understanding anyway, that the outdoor riding arena was in this area. If you can see the stone fireplace that's here toward the background. But I don't have the compass directions to provide the board for that. But this next photograph is after construction had started. You know, what the Swishers are seeing from their home with the, you know, the same stone fireplace in the foreground. And then this is after the construction's been completed. Now the view from the Swisher's home has been completely blocked. And, you know, what used to be a nice view out into an open pasture is just the side of this building. They look at sheet metal every day. And then, of course, we have the view from inside the Swisher's home with the sun glaring directly into their home off the roof of this building. And so, and just some photos of the exterior, the additional grading that was done to level the riding arena. This is an aerial photograph that kind of more illustrates the proximity. And then there's actually a Google Maps image that I included but didn't mark as an exhibit that just kind of further illustrates the distance between the side of the riding arena and the Swisher's house. You know, if taking what the construction contractor had stated about the riding arena being 75 feet across, we're looking at more like 100 feet between the edge of the building and the Swisher's house. And so, so with that, I would like to simply open it up to Mr. Swisher. Carl, if you could just speak briefly about the type of impact that that this has had, you know, how you've been affected, how your property's been affected, and that type of thing.
I'll be glad to do that. First question I have, though, is for the members of the board. Have you all received the package that I put together in advance of this? With the pictures?
I have.
Yes.
Yes.
Mhm.
Okay, so everybody on the board actually has that document. And have you had a chance to review it?
Definitely.
Mr. Swisher. I'm sorry, go ahead, Mr. Swisher.
No, you were addressing me. Go ahead.
Yeah, I was going to ask, can you just be specific as to what document you're referring to?
It's a PowerPoint presentation that was printed out, approximately 15 pages. It says City of Wildwood Board of Adjustment hearing Thursday, February 17th, 2022. And it was hand delivered on Tuesday afternoon to the city court, to the city hall. 6 copies, one for everybody. And we were assured that you would have them in time. Now, if you don't have them, I'll be glad to share that document right now.
If you have it accessible, I would like to review it and just ensure that we're all looking at the same document and the same, you know,
Okay.
question. I'd like to be able to pinpoint that.
All right, very good. One moment, please. Hard to do. Where did they go?
Hey, Jared, while Mr. Swisher's bringing up his document, I did receive one, but it's like 64 pages long. Did other
No.
members receive one?
No. Can you see my document now?
Yes, sir, Mr. Swisher.
All right, I'm going to go full screen on it.
That'd be great. Thank you.
All right, very good. And I'll be as brief as I can with this. So the photos that were used previously in the City of Wildwood's presentation were taken in 2019. They're not current. These are Google Maps photos that are current, and you can see the position of the new riding arena in relation to my property, in relation to the property line. If you look on the picture on the right, That light blue line is an approximation of exactly where the property line goes. And then you can see the riding arena in relation to the 1901 residence and then my house. This is a more accurate depiction of the magnitude of this structure and how close it is to my residence. You know, there's a reason that Chapter 415-090 exists. And there's a reason for the setback of a building that's 10,000 square feet. I mean, that's almost the square footage of 4 houses. And it's oversized for the location. It severely blocks my view from both outside and inside my home, and has a pretty severe negative impact on my septic field. So imagine that you're me and you're trying to enjoy a barbecue on your back patio with your friends and family, or you're actually trying to do some gardening or play with your children in your backyard, and all you can see is steel and shadows and glare. It's just terribly unsightly, and has really diminished our enjoyment of the house that we've lived in for 21 years as a resident of Wildwood, and we're not moving. Here you can see the same photos that Eric showed. No need to dwell on these, but I think it's quite a contrast of what was there when the indoor riding arena was in place, and also with this new building. You can see pictures out of the back side or the west side of my house. Every window on the first floor, every room on the second floor is impacted by this arena that is 30 feet from the setback, and it should be 100 feet. Imagine the difference that this would make if it was an additional 100 feet where it belongs. It's very hard to tell from these pictures exactly how severe the glare is. The camera sometimes doesn't do it justice, but you know, imagine sitting in your dining room trying to have a meal, and right through the window is this horrific glare, which I can't imagine would be there if the building was in another location. All right, finally, let's talk about the impact on my septic field. The arena and its runoff is actually uphill or upgrade from my septic field. So its discharge is going to run down into it. So there's the approximate riding location. This blue line here is a swale that was graded out to collect the effluent and discharge it into another location. It's minimally effective. Here's my diagram of where my septic is. It's 30 feet from the property line, and then the building is another 30 feet beyond that, okay? And then we've all seen these pictures. No need to talk about what that would do to your leach field. But here's something I want to touch on. The International Plumbing Code talks about how a private sewage disposal system is supposed to be designed. And the minimum distance from a swale down here, streams and watercourse, it should be highlighted, it doesn't show up. Streams or watercourse, 50 feet. And this swale is 40 feet. So we've got 30 feet to my property line, then we've got another 10 feet and another 20 feet. So it doesn't comply with International Plumbing Code standards for where, you know, where a building or a runoff is supposed to be in relation to a septic field. Nobody talked to me about where my septic field was. Nobody surveyed it. Nobody asked me. So there's that. And then this picture here shows basically the magnitude of the runoff from that huge roof. And although at this point grass has been planted here, it still shows what the actual capacity of that swale is. And you can see where it is in relation to my fence or the property line. And I also wanted to note that the International Plumbing Code has been used previously as a reference in front of this Board of Adjustment back in February 20th of 2020 in a proceeding that involved, down here, a proceeding that involved Giselle Kuhn wanting to relocate her septic field outside of the normal variances. And she was granted her variance, but my point is that International Plumbing Code does have weight with the Board of Adjustment, or it has in the past. And, you know, this is something I put together, and I know that Mr. Rupert has got many years, and the surveyor has many years of experience. But, you know, you can see here I dropped a 100-foot setback line on the topographical map. And it's, to me, and I'm a layman, I tend to believe that there are many other several other locations here where that building could be relocated. And I believe, and correct me if I'm wrong, that when a variance for hardship is being considered, financial hardship cannot be one of the considerations. And so, you know, in conclusion, I guess where I'm headed is that there are reasons why Code 415090 exists. And those reasons are represented by the negative impact it's had on my property value, the enjoyment and satisfaction I get out of where I live, and the potential or damage to my septic leach field. And it's my opinion that there's no topographical hardship in preventing relocation of this thing. And, you know, maybe the fourth point is kind of combative. I don't know. Ignorance is not an excuse for violating written laws or ordinances. But I believe that. And, you know, if the police officer tells you you don't need to worry about the speed limit sign and you go ahead and you get a ticket for speeding, you know, you can't use that argument. So, you know, in summary, I'm asking that the Board of Adjustment deny this variance. And, you know, the remedy for that is not up to me, but I think that the ordinances and the laws that are in place should be upheld. Since I have the floor, I want to, and I am under oath, I totally understand that. I want to address something that Deborah asked about when I first learned about this project. And my memory is very different than my neighbors, but I will just state it, is that approximately 2 weeks before groundbreaking commenced, I went over to the neighbor's house to complain about their guinea hens being an incredible nuisance. Now, I'm not a complaining neighbor, you know, but there were these guinea hens that had been over there for several months, 12 of them, very noisy. We have chickens. It was very disruptive. And I'd basically come to my wit's end. And I was basically saying, look, you've got to do something. I can't take this anymore. And at that time, she had told me that they were going to build a riding arena where the existing outdoor arena was. And it just wasn't going to be that much. And it was going to be 30 feet from the property line. That was the extent of our conversation. No plans were ever shared with me, no photos, no layouts. And you have to understand that the footprint of this indoor riding arena is far, far greater than the outdoor riding arena that was already there. And the grading involved considerably more. So, you know, I just want to state that for the record. I'm looking at some of my notes here. I think that covers it. If I think of something else, I'll interject.
Okay, thank you, Mr. Swisher. Mrs. Rumsky, anything else you would like to add?
No, I don't believe I could add anything to what Mr. Swisher's already tested.
Oh, sorry, I did think of one more thing.
Go ahead, Mr. Swisher.
We're talking about awareness of, you know, construction. Once construction commenced, I really dragged my feet about what to do about it. I didn't want to retain a lawyer, but finally I decided I needed to do it. Both the neighbor and Morton Buildings were aware before completion of the structure that there was a temporary restraining order in place that referenced the violation to the zoning codes. Now, theoretically, construction could have stopped until it was sorted out, but we didn't actually have the restraining order in place. And so, you know, they chose to proceed.
I apologize. I don't mean to interrupt you. To clarify, no, we did move for TRO that was not granted. So we did not have a temporary restraining order in place.
And the reason that it wasn't granted was that the judge said that whether the building was completed or not, it would not sway his opinion of the matter. Can I say that?
I mean, that is my recollection, yeah.
Yeah. So, to sum things up, there was also some numbers talked about in terms of investment in the property, walls, retaining walls, things that were done. All these improvements were made not only during the TRO application, but once the lawsuit was actually accepted by St. Louis County. So the lawsuit's accepted by St. Louis County, all the codes are referenced, yet investment in the building continues. So now I think I've finally gotten through all my notes. Thank you.
Thank you, Mr. Swisher. Anything else you gentlemen would like to add?
No, nothing for me. Thank you.
Thank you. Mr. Vunich, are there any other members of the audience that would like to?
Oh, okay.
Mr. Chair, there is. I'll promote the gentleman now.
Okay, thank you.
Mr. Chair, Mr. Cordes is now on screen.
Good evening, Mr. Cordes. Can you please state your name, address, and relationship to the petitioning property? You might still be muted, Mr. Cordes. Are you there?
I am.
Okay.
Can you hear me now?
Yes, sir, we can. Can you please state your full name, your address, and your relationship to the petitioning property?
My name is William Cordes. I live at 1741 Shiloh Ridge, which is in the subdivision.
Okay, can you be sworn in for the court reporter, please? There you are, Mr. Cordes.
Do you solemnly swear that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
I'm the longest resident of the subdivision. I've been here almost 40 years, and I'm intimately familiar with all the properties. I've walked them before most of the houses were even built. I'm familiar with this property. They have almost 12 acres. And to say this is the only building site is wrong. They had plenty of choices. They could have built this, whatever. They just picked the easiest building site. And that was their choice. And I'm not in favor of giving them a variance. They chose the site. They could have built it at a different site, but that's what they chose, and they shouldn't have built it there to start with.
Anything else you'd like to add, Mr. Cordes?
No, basically that's it. Like I said, I'm familiar with the property. I've walked that property several times when previous owners owned the property, and they could have built that arena at a different location. They just picked the easiest building site.
Okay, well, thank you for your input.
Well, thank you.
Mr. Vunich, Director Vunich, any other members of the audience like to speak in favor or against this petition?
Mr. Chair, there are no other attendees using the raise hand feature, but I would like to ask them. Pardon me, there's now one. I'll promote Daryl. Mr. Chair, the gentleman should be coming on.
Good evening, Daryl. Can I have you please first unmute?
Hear me now?
Yes, sir, we can. Can you state your full name, address, in relationship to the petitioning.
My name's Daryl Carpenter. I'm at 1930 Shiloh Oaks Drive, Wildwood, Missouri. We've been residents here since January of 1988. And if this variance would be approved, I think that sets a serious.
Mr. Carpenter, I'm sorry to cut you off. I apologize. Can you please be sworn in by the court reporter before you move forward?
Do you solemnly swear that the testimony you're about to give in this cause would be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right, thank you, sir. Please proceed.
Yeah. I think if this variance would be approved, it'd set a serious precedent for what could happen. I have property that backs up the country trails to 5 properties there. I back up to the 1901. I have a 150-acre lot beside us. We back up to, and if that would get sold, I just think this would set a serious precedent people could point to. So I agree that this should not be approved for this building.
Thank you, sir, for your input. Anything else you'd like to add?
No.
Okay. Thank you much. Director Vunich, do we have
Good,
any other?
Sorry.
That's good.
Good, Mr. Chair, I'll ask one more time if there's any other attendee that would like to speak on this matter. If you would please use the raise hand feature, I will promote you so you can speak on it. Mr. Chair, no one has acknowledged their desire to speak at this time. Thank you.
You're welcome. Director Vunich, your thoughts on opening up for any questions, or should we proceed and then just prior to closing, see if there's any final comments or questions?
Mr. Chair, we've had several people from the public speak. There may be questions on the part of the board members. I know Mr. Sides has his hand raised right now. So I would ask you to offer an opportunity for the board members to question any of the speakers.
Absolutely. Well, we've got everybody on. I think that's a great idea. So we'll open it up for the board members to ask any questions to any of the parties.
I'll just say my raised hand thing has been up there permanently. It won't go away. So I don't know what's going on with it. But since I'm on, I will ask a question for Mr. Swisher. You're still there, right? Okay.
Yeah, I'm here.
You brought up the effect it's having on your septic system.
Mm-hmm.
And I was just sitting here looking, trying to find the distance to the property lines. Your field seems very close to the property line for me. I don't know.
If
They're all different, designed differently. Go ahead.
If you reference the survey that's on one of those, do you have that packet of slides, or do I need to share again?
No, but I got a good look at it. You said it was 30 feet from the property line.
Yeah, if you you know, that piece of paper is 2 feet by 3 feet, and I reduced it to 8.5 by 11. On the original document, at the top of the septic field to the property line is a notation that says 30 feet.
Okay, I understand that. I'm saying, in my opinion, from my experience in the past with septic systems, 30 feet is usually way too close to the neighbor's property.
That's the code.
Go ahead. Go ahead. You can.
Yeah, that's the code, 30 feet. Correct me if I'm wrong.
Well, I was trying to find it, and I can't find it right off the bat here. But I do know that it's not a consistent code. It all depends on an engineering.
What's important is the code of Wildwood or the code of the St. Louis County, isn't that's what's pertinent?
It's St. Louis County. Wildwood doesn't have a code,
okay,
as far as I know.
Well, you know, the septic field was built by a licensed contractor. It was inspected. It passed inspection. You know, it was built within compliance of, you know, codes that were in place at the time, or it would have never gotten the approval for a move-in.
Ironically, it's the same issue we're dealing with on the other side of the fence. But I can't say any more to it because I can't find the exact distance right now, but it did raise a red flag to me, and you're the one that brought it up, so I just wanted to ask you about it.
Yeah.
Because I honestly feel like this board is being put in a territory we shouldn't be in. I probably don't have any right to say that because I'm just.
I'm very empathetic to your plight. Believe me, I wish I wasn't here either.
Yeah, I'm sure you do. That's my only question. Thank you.
Yeah.
Jared.
I just happened to see Mr. Sprunger first, but I see Ms. Coleman, Mr. Rubis.
Go ahead. I'll wait.
Okay, Ms. Coleman.
Okay, I do have a question for Mr. Swisher's attorney. I forgot his name, I'm sorry. But did I get this right? Did you say in the beginning that the property with the arena is already up for sale? Did I hear that right?
Our understanding is that the property with the arena, Ms. Maxwell and Ms. Lewis's property was listed for sale in about January, mid-January, and is now under contract.
To be sold?
Correct.
I see. Okay, thank you.
Mr. Rubis.
Yeah, Mr. Swisher, when you became aware of the impending problem and you started investigating, did you go to the city of Wildwood and inquire about what the heck was going on?
Yes, I did. I contacted Steve Vogel first, and then I had direct correspondence with Joe Vunich.
Okay, and
and also John Gragnani, our Ward Alderman, Ward 1 Alderman, was aware of all this.
Okay.
And quite frankly, there was no satisfactory response from the city about how to resolve this.
Okay, did it seem to you that this structure was going to be pretty darn close to your property?
Well, yeah. I'm sorry. Can you? I'm not sure I understand.
Okay, so one of your concerns, this is a question, not a statement.
Okay.
Was one of your concerns the proximity of this building to your property?
Without question.
Okay. In your dealing with the city, did that come up?
Absolutely.
Okay. Did anybody from the city come out and look at the problem you were indicating?
John Gragnani and his wife came out. They were our aldermen.
Uh-huh.
At some point, and I have trouble with the timeline, representatives from the city came out and they examined the building, but their examination did not address the ordinance in question. It addressed whether it was by definition a horse stable or a horse riding arena. And that was the extent of their investigation, and it never addressed whether it was in violation of an ordinance or not. And if someone else has a different recollection, I'd like to hear it.
I apologize. If I may add to Mr. Swisher's answer, that is correct. We received a correspondence in about July of 2019 from the city of Wildwood. The correspondence was actually directed to Ms. Weiss, but we received a copy of it where the code enforcement had come out to take a look at the riding arena. It is our understanding that their determination, their scope of their investigation was limited to two things. One was whether the petitioners in this case, Ms. Wise and Ms. Lewis, were operating a business out of this riding arena. There were some posts on Facebook that indicated that they may have had an LLC related to equestrian therapy of some kind. The other issue that they had investigated was whether or not the riding arena itself was capable of being used as a stable. And I believe that's because there is a different set of zoning regulations that come into play. And I'm not able to quote them from memory for the board, but there is an addition, there is another set of setback standards if it's a stable versus if it's a riding arena. And so when Wildwood came out and looked, those were their only areas of investigation, and they made no determination whatsoever as to the setback requirement that we're talking about tonight, which is for an accessory building in excess of the 3,000 plus square feet.
Okay. My next question is that Miss Maxwell, Miss Lewis, they're under the impression that the setback is 30 feet. They told you that it was 30 feet. When did you become aware that it wasn't 30 feet, that in fact it should have been 99 feet or 100 feet? You're muted.
Sure. I just couldn't believe the city would allow this. And so I started tearing into the codes. And I went over the codes and I went over the codes, and I found this ordinance about the 9,800 foot setback. And that's when I addressed the city about it. Why isn't this ordinance pertaining to this building? And I didn't get any replies. So I wasn't aware of this. I wasn't aware of the size until it was built. And then I just couldn't believe that this would be allowed. So that's when I discovered it on my own. Okay. And was that prior to filing suit or after the suit had been filed? Prior to filing suit. Okay. And also prior to filing suit, I want to mention that my wife addressed the city council. I think it was on June 10th, 2020. So she, 2019, June 10th, 2019, she actually addressed the complete and full city council with the mayor and everybody, and expressed our dilemma, expressed our case, expressed why we thought this wasn't right, and she pleaded for help. And the help you got? Never materialized.
So I'm going to jump in here, Jim. Is that okay? I want to do a follow-up on your question.
Yeah, I'm fine.
Okay, thank you. So, yeah, so on this whole timeline thing, and I know it's always hard to remember everything, but are you saying, Mr. Swisher, that in July of 2019, you knew about the 100-foot setback requirement? Did you know at that time?
Probably so.
Well, probably, because I think part of what's going on here, I'm sorry, part of what's going on is we're trying to figure out, the petitioner thought they were compliant. They thought they were, okay? Well, I think their position is, well, it wasn't until we had the thing built and it was all done that we found out that, quote, we weren't compliant.
No, instead of answering your question, I'll make a statement, and if you need it answered, I'll circle back. Prior to completion of the building, they were made aware that there was a temporary restraining order being petitioned that cited the ordinance, and yet construction continued until completion.
And when was that?
Eric,
When, from a timing perspective, when did that happen? Because
Eric?
you're saying you basically you notified them.
Oh, absolutely.
Yeah,
In fact,
okay.
Mr. Rupert from Morton Buildings, we walked over there and carried the written lawsuit to him. And we faxed it to Morton Buildings headquarters in Morton, Illinois, and gave it to Jolene.
And when was that about, kind of, when was that?
Eric, whenever we first initiated the lawsuit.
Carl, I apologize. I know it was 2019.
Here.
I am looking it up right now on.
I was going to go get it out of my drawer.
Sure. Give me a moment and I'll be able to more directly answer that.
That's fine. While you're looking that up, Mr. Zarumsky, I do have a few other questions for Mr. Swisher and even one for Mr. Portis if he's still hanging out. But yeah, I see him there. Okay. So what I'm hearing you say, Mr. Swisher, is that there are two main issues that you have with what has transpired. Number one, you have visual impact. You have to look at it every day. And when the sun shines, it reflects itself on you. Okay. That's number one, the whole visual thing. Number two is the drainage or the water that runs onto your property, onto your septic field. Is that correct? Those are the two issues?
Those are two of the issues.
Well, I'm trying to get
I mean, if you're headed towards thinking about putting up a green screen, that's going to be just as visually impactful as the building itself. And it's also not going to do anything towards what it's done to my property value.
Yeah, well, and this is a real little, I mean, this is a dilemma that we as the board have. We have a situation here where I am so sorry to say, if we vote yes or no tonight, someone's going to be very relieved and delighted, and someone's going to be very upset and angry. No matter which way we go, we feel like we're in like a no-win situation. So what I think about in situations like this is there any way to find a solution to this issue where it may not be the best thing in the world, but at least it's acceptable to you, Mr. Swisher, and to the other party. And let me just say this. You do know, and brother, I sympathize with you because I've had some experience, not exactly like yours, but somewhat like yours. And so I really do empathize with your situation. But you do know that, let's pretend for a moment that the board were to vote no. And let's just pretend for a moment that maybe it's not that bad to really move that building. It's going to be expensive, but that's not the board's issue. If they put that building back 60 some odd feet or whatever it is, so that it is 100 or 98.1 feet back, you still are going to wake up and you're still going to look out your window and you're still going to see a horse barn. You are.
You're projecting onto me what my thoughts and feelings are going to be about it, and that
it's still going to be visible, isn't it?
Depends. Sure, it's going to be visible, but it's not going to be right up on top of me. It's not going to be looming. That it's 30 feet tall, and right. So if you move it back to 100 feet, the trajectory as it is great.
Yeah, no, you're right.
On me.
No, you're right. I don't mean to argue with you, but I just want to make sure that we're all clear on this. You'll probably get rid of the septic or the water runoff don't you still have a building that you're going to have to look at, and I don't know what to say other than I think they do have the right to put that in as long as they're compliant. I mean, I know it's just terrible situation.
Let me just throw this out there, since we're talking openly, where's culpability to the city of Wildwood here? You know, we all make mistakes. I make mistakes, but I own my mistakes. And, you know, the city of Wildwood gets away scot-free here. Where's their culpability? Where's their sense of responsibility? Where's their sense of righting a wrong? There's probably some actions that the city could take. It might cost some money, right? But the city could, you know, intervene and finance some of this remediation or some of this relocation.
If I can kind of piggyback on some of this and to address one of the questions that was raised previously, regarding the timeline for this, we were made aware of it prior to June 10th. That was our filing date. Motion hearing was, or the motion was filed that Mr. Swisher referenced on about a week later, June 18th.
And we're talking 2019, right?
Yes, sorry, June 10, 2019, and then motion filed June 18th. Service was June 20th of 2019.
And did you provide a copy of that to the city at all?
I believe the city was much later after after we had received a copy of the correspondence that I had referenced previously, the July 2019 correspondence. We served City of Wildwood in September.
Okay, and so what happened after you served this notice to Ms. Maxwell? What happened? Did anything change with construction or anything?
My understanding is no. My understanding is they, well, to the extent that it changed, it moved forward regardless of our filings.
In addition to improvements subsequent to the filing.
Okay, so they didn't stop, to your recollection or your knowledge, they didn't stop to check out this reference that you provided to them indicating being in violation of a Wildwood code.
That is correct. That is correct. And like I said, not just stop finishing the building, but continue to make improvements above and beyond. Bill, you're on mute.
Are you done?
Okay,
Oh,
I'm sorry. I do have one last question,
Okay.
and that's from Mr. Cordes. You know, you had mentioned that you've walked the property, you know, all around you, and you said, right? If I heard you correctly, Mr. Cordes, you feel like there would have been other locations that they could have built this arena on. Now, and I don't mean to press you on this, but I will. You know, are you qualified to really make that assessment that they really
Well, I'm
could?
not an engineer, but like I said, I've lived out here. I've walked every property. It's not easy building in West County, as everybody can tell you. And again, they picked the easiest site. They didn't pick the site. They could have picked another site. It would have been more difficult to build, but they could have built it there. But they picked the easiest site. They didn't pick the only site. They just picked the easiest site. And if you walk the property, you could see that they could have built it in a different location, but they chose the one they did. And not only does it obscure Mr. Swisher's, it's even, if they would have picked another site, they probably would have been looking at it, which they probably didn't want to do. And so it's further away from their house and closer to his house. I think it was intentional exactly where they built it. Not only was it an easy site, but they didn't have to look at it.
Okay, thank you.
Okay. Mr. Rubis?
What in the lawsuit, maybe Mr. Zirinsky, what relief are you asking for in the lawsuit?
So there's a difficult question, and I don't mean to evade it simply because there are attorney-client concerns with respect to specifics regarding the lawsuit. Now, that said, I know the city of Wildwood has been a party. I'm comfortable in saying that part of what we're seeking is an injunction to have the building removed.
Okay, so you want it removed. So if you win your lawsuit, the building comes down.
It comes down, yes.
Okay. That's all I have.
I actually have a question. It's not even for Mr. Swisher or Zarumsky or Mr. Cardis. It's actually maybe a clarification for Mr. Vunich. I'm sorry, Joe, to put you on the spot, but I'm going to here just a little bit. If the board votes, well, I know what happens if they vote yes in terms of kind of what that means. I mean, now it's in the lap of Mr. Swisher and whoever to deal with it. But if the board votes no and they say no, we're just, this one's just we're going to vote no. What practically does that mean in terms of what the city then does in relation to that building? What does it really mean?
That will be a discussion held between the city council, the mayor, the city attorney, and the city administrator.
So it's not clear what the city would actually, what actions they would or would not take.
I can't predict that, and I believe the decision makers will take the information they receive, apart from tonight's discussion, and make the best decision possible.
Okay, thank you. I didn't know if there was like a prescribed action that it's like, well, in this case, this is what happens. But it sounds like there's not, a standard response to things like this. Am I understanding that right, Joe?
Well, in the time frame I've been here, this is the first time that we've had a case of this nature. So it's hard to have a prescribed approach.
Thank you.
Got a question for you. In this case, for anybody that knows the Blackwell team or anybody on the board, there's been a lot of talk about the size of the building, the look of the building, the shininess of the building. Other than the setback problem that we know about, is there anything else that is not code compliant about the building?
Well, Mr. Sides, I'll do the best I can. Other than the setback, we did not advertise it for any other variances. And relative to the other setbacks associated with the remaining boundary lines, there is no encroachment. And our code does allow these size buildings, again, albeit with an increased setback.
Okay, thank you.
Any other questions from board members to any of the related parties? Since we had a lot more discussion, Joe, any other speakers in the audience that may have would now like to speak in favor or opposition, just in case that swayed anyone's mind?
Well, I believe Mr. Rupert would like to, well, Mr. Rupert has already spoken, but has his hand raised again. And then the petitioner has their hands raised.
Okay. Great, Mr. Rupert.
I apologize. My computer had to do a restart, so I got kicked off the panelist. That was the only reason I had my hand up.
Okay.
Ms. Maxwell and Ms. Lewis, anything else you guys would like to add?
Can you hear us?
We can. Yes, ma'am.
Okay. Okay, great. Well, and thank you all. I mean, this is a process which is, is time consuming, and I think you've been very patient to allow everyone to, get their information out. I do think that we need to respond in connection with the comment that was made in an attempt to, file the lawsuit. On July 29th, 2019, the city of Wildwood did send a letter to Miss, Kathleen Weiss at the time, Maxwell, where they specifically said that the setback was 30 feet. So it is a letter that the city has in its files. I would like to mark it as an Exhibit 26, and I will send it to everyone. But it was in connection with an investigation as to whether there was any operation of a commercial business on the property. And in connection with that inspection, there was a discussion that was had, and the inspection was completed, and the two areas of concern were addressed. And in point 3 of that letter on July 29th, 2019, it stated that if the outbuilding, the arena, became a stable, that the side yards of the property would go from a setback distance of 30 feet to 100 feet. So even as late as July 29th, 2019, the city of Wildwood, the owners of this property, were all of the impression and belief that it was a 30-foot setback. Mr. Rupert built the property 31 feet off the property line because of this understanding. These owners did everything correctly in terms of getting the proper permits. And yes, we feel like Mr. Swisher, who did everything to get his leach field where it was. This building was built in accordance with all of the rules and procedures that were in place. And it was built by July 29th, 2019. Is there anything else you want to add?
No, just wanted to explain that.
Well, if you could explain that, yeah.
I think you did a good job of explaining it. It's just that it shifted over time. When the lawsuit was first filed, it was filed as that we were building a stable, and that a stable would need 100-foot setback. So that's why we continued. And then when that didn't prove to be correct because the inspection was done and it's like, oh, it's not a stable, then it was changed and the city of Wildwood was pulled in. And then that ordinance was mentioned about, oh, there's a problem with the setback. So then I called the city of Wildwood and said, oh, they're pulling you in now. And they say that there's an ordinance there's been a mistake on. And the person that I spoke to in the enforcement part, in the code enforcement section, said, no, it's okay. We're confident we didn't make a mistake. And at that time, they believed that they had. So I was like, okay, all right, we're okay then. We'll keep going. So we were still moving forward under the belief that there was not a mistake that had been made.
So Ms.
And just to sum
Maxwell,
up, sure, go ahead.
sorry. So I'm trying to keep these dates kind of lined up because they actually might kind of matter here. So the lawsuit, or at least the understanding I have, the serving you notice about the intention for a restraining order or something like that. I thought that was in June of 2019, or maybe it was July. I'm not sure which it was. Are you saying that you were not made aware of that ordinance number until after the building was already finished and was already built?
The dates that I have are, we received after June of 2019. That's when we received. So it must have been around the 16, 17, 18, somewhere in the middle of June, we received the first we're suing you papers and the request for an injunction. So when I read it, it said we're seeking that because it's a stable, and a stable gets a 100% or 100-foot setback. So I thought, okay, well, that's okay because we're not a stable. And once we clear that up, we'll be okay. And then the judge denied the injunction. So I was like, okay, we're okay. And then the Swishers changed it. And so then they pulled in the city of Wildwood, and then they came forward with the ordinance. And so that was when, where's the letter? When the code enforcement agents came out, they came to see me on June 27th of 2019. And so that's when they came, because they were looking, is it a stable? And that's why they say, no, it's not a stable, along with the other claim that we were running a business out of it. And they said, nope, there's no business being run out of it, and it's not a stable. And so the 30-foot setback is fine because it's not a stable. And I received this letter July 29th of 2019. It was about a month after their visit that they sent me the letter, July 29th, saying that there were no violations.
Okay, yeah, I'm sure that was confusing as heck for you. But to be clear, in the letter that was the notice that was delivered to you, okay, in June, did it actually reference the ordinance number by chance?
The first one didn't, but the second one did. That's why I called Wildwood and said they're listing an ordinance, and they're saying that there's a problem with the ordinance. And that's when they said, no, there's not. We're fine. We didn't make a mistake. We're okay. And
Okay.
so they just didn't realize at that point that they had made a mistake.
Okay, so when was to your best recollection, when was the information of the ordinance provided to you? Was that you're saying that wasn't the June one, that was the July? Or when was that?
No, it would have had to have been after July 29th, because they came, the issue of the letter saying everything is okay because it's not a stable came on July 29th. So it would have to been after that. And I'd have to look into the filings to see. I don't know for sure.
Okay, that's okay. But again, what I'm hearing you saying, this is important, at least it is to me. When you were notified with the specific reference to the ordinance that was problematic, are you saying tonight that the riding arena was already constructed? It was done.
For all intents and purposes, it was done. If that was July 29th, August, September.
August 5th was the final inspection.
August 5th was the final inspection. So yeah, July 29th. So right, the next week or two. So it was already built. It just hadn't been signed off on yet.
Okay,
Exhibit 6, Exhibit 6 references the final inspection. It was obviously already built then. That was August 5th, 2019.
Yeah, I saw that the
Exhibit
final
6.
sign off. Yeah, I saw the sign offs were in August. Yeah.
But I do think this is important. I guess we didn't anticipate this discussion, but I am going to introduce as Exhibit 26 this letter of dated July 29th, 2019, because I do think it's important that the city was taking the position as late as July 29th, 2019, that it was a 30-foot setback.
Right. Yeah, I think I understand that. Mr. Swisher, so I'm going to actually ask you a question now, and I'm sorry, this is running late here, but we're going to quit soon, I think, probably. But
I think my lawyer has some information on that timeline that you're interested in.
yeah, what I'm trying to drill into is, when did Ms. Maxwell know about the reference to the ordinance that you discovered? I'd like to really know that.
I think that's what Eric has. I think Eric's got documentation.
And where is Eric?
He's got his hand up.
Mr. Sprunger, if I may, and what you need to understand about the sort of climate while this was ongoing. I mean, the structure is going up, without, we have no information about what this is, what the nature of it is. I mean, obviously we weren't consulted, we weren't given any, and by we, I obviously, I mean, the Swishers weren't given any information about it. No chance to be heard publicly about it, which should have happened. And so as we're preparing to file for an injunction, you know, we're under the impression that, yeah, this is a stable. There are additional setbacks, and I don't think there's any functional distinction. The outcome would have been the same, whether it's under the current setback requirement that we're talking about for an accessory building versus the setback requirement for an actual stable. It's still a 100-foot setback. And so, you know, when we initially brought this, it was with limited information. And so then as we kind of learned more, and then as Wildwood had come out and taken a look, and then issued the city's statement that, you know, this thing was fine. It violated no ordinance of any kind, which is what the crux of the letter was. We took a step back and said, no, that's not right. That there obviously, very, very obviously is a violation of the ordinance. Now, it wasn't the one that we had initially referenced when we thought it was a stables. The distinction wasn't made clear, but, you know, once we figured out that the city had said that there is no problem, well, that's when we brought Wildwood in. And it was on, you know, it was a petition for a request for declaratory relief, simply to clarify whether or not there had been a violation of the ordinance. And I think now that we're here tonight, there clearly is.
Okay, thank you for that clarification. It sounds like, yeah, okay, thank you.
Mr. Storm, I just had a question for you. If the petitioner feels that they're being told they're completely compliant, no variance is needed, do they owe you or your client any thoughts? Do they owe you any obligation to tell you what they're doing? You said they didn't consult with you. If they feel and they're being told that they're completely compliant, do they have any obligation to tell, other than it's the neighborly thing to do by law or anything else? Do they have to consult at all with you or your client?
I think they had to apply for a conditional use permit to put a 10,000 square foot structure almost directly on a property line. I think that,
but if it is, but
it was, I mean, frankly, I think it was negligence to put this. I mean, come on, it's 10,000 square feet, and you're putting it 30 feet from the property line. You're putting it basically in your neighbor's backyard, and you don't think that maybe there's some additional code that might need to be consulted, that maybe there's something wrong with what we're doing? That's ridiculous. And I'm not saying that your question is ridiculous, but the thought,
you know, I'm wondering, you know, at the end of the day, whose job was it to inform Ms. Lewis that she was in violation of a code? Was it my job to be articulate and precise, or was it the city's? While we were talking, I just pulled up a letter I wrote to Joe Vunich on June 12th, and I can share it on the screen if you want. But, you know, this is where I talked to him about my concern that if it's a riding stable or a horse stable, it should have a 100-foot setback. If it's a structure over 3270, the setback should be in excess of 80 feet. So we were already hitting the city with our concerns about this violation of the ordinance.
Mr. Chairman, that question isn't relevant to the proceedings, and I'm going to advise the board not to answer it or any member of staff.
Fair enough.
I have questions.
Yep, go ahead, Mr. Ruth.
I see John Young, our attorney, in there. In past Board of Adjustment meetings, I think it's been said by the city, I don't know whether it was from attorneys or from the department, but our decisions that we make are kind of they're independent of anything else. So we make a decision tonight on something and a similar case comes up next month. We're not like the Supreme Court where we have precedents. We have to take
Mr. Rubis, you are absolutely correct. We do not set precedent here. That's
okay.
by definition, our Board of Adjustment, we deal on every circumstance, various circumstances. Each variance is evaluated and on its own merits.
Okay.
So correct. Nothing we would say here would transfer to the next property over.
Okay.
By virtue of precedence, unless
and
Attorney Young can elaborate if he feels, but
yeah, that's what I was wanting to reset my mind, because that's always been my judgment. Mr. Zarensky, is the lawsuit still ongoing?
Yes.
Okay. Is it a you're looking for a declaratory judgment before a judge, or are you gonna ask for a jury too?
That's not something I can address tonight.
Okay. The other, do you have any anticipation about when this thing may be adjudicated?
That's also not something I can answer.
Okay. All right.
any other questions from the board pertaining, from a kind of realigning our focus to this specific variance and what our duties are? Because it appears we're getting towards the end here. I just want to make sure that everyone's questions, concerns, comments have been heard, and we'll proceed. Seeing none, at this time, I'd like to offer the opportunity to hear any oral presentation of the department's report, if requested. Okay, seeing none, does the Department of Planning have any final comments they'd like to make?
Mr. Chair, thank you. Mr. Chair and members of the board, the department has provided a report with recommendation. And as part of that recommendation, it does develop findings of fact. And one of the findings of fact relates to providing a landscape screen as a component of any favorable action the board might take relative to that common boundary line. If there are any questions regarding the report, the department would be glad to answer them at this time.
Mr. Rubis?
Yeah, I just had one more question, and I hate to keep harping on this, but again, Mr. Zarensky, on the lawsuit.
Mr. Chair,
Yeah.
I believe we concluded the public comment at this stage.
I was about to say the same thing, that we did conclude any questions. We closed.
Okay, well, I have a question for not the petitioner or Mr. Swisher or any of that. It's really more about.
Well, we're just be Arnie, I apologize. I don't mean to cut you off, but is this a comment or questions? Because we have moved on from questions. So I just want to make sure this is just an overall comment.
I thought you asked if we had any questions about the recommendations that Director Vunich had.
Oh yeah, correct. Yeah, I just want to make sure you weren't addressing any other party.
No, I'm not. I get that we're past all of that. That's fine. So, Mr. Vunich, to the best of your recollection, when do you remember either you or anybody in the city being informed that, like, this particular ordinance number was in violation, or at least that's what Mr. Swisher was saying? Hey, there's something wrong here. There's a violation here. Do you remember at all about when that happened?
Mr. Sprunger, I received an email on August 2nd of 2019 from Ted Bisbesio, who is an attorney, I believe, with the firm of Mr. Zaromsky. And at that time, he identified that he was representing the Swissers and that he quoted the citation relative to as the outbuilding grows in size or increases in size, excuse me, the setback has to be also increased relative to the formula John Young had mentioned. So from that perspective, I responded back on August 3rd. On August 5th, I asked him to request the response in the form of a sunshine request. And then thereafter, it was submitted on August 8th.
Okay, so the soonest that you,
Arnie, hold on if you don't mind, just a second. Robin, Attorney Young got kicked off the as a panelist. Can you see if you can bring him back on, please? Mr. Chair, we were supposed to stop comments. We're going into areas that we should not be going into. With all due respect, Arnie, that we should not be going down this road.
okay.
Mr. Chair, it's up to you, but
No, I agree. I don't know what that, ultimately our task is to weigh the merits of this particular variance. And does this present the necessary hardships to either approve or deny or approve with conditions. So I think it's best. I think we all agree there's plenty more discussion can be had in other arenas, but let's get back to our focus tonight and proceed. That being said, I will go ahead and close the proceeding for a vote. At this time, is there a motion to approve, deny, or approve with conditions?
Well, Mr. Frank, Jared, we've been at this now for quite a long time, and we received a lot of information, both from Ms. Maxwell and Mr. Swisher and so forth. I don't know about the other board members. I'll do what they want to do, but I'm still trying to digest all of this, and I'm wondering if it might not be appropriate to call a timeout so that we can look at this information a bit more before we actually vote. So I'd like to, if it's okay, to maybe hear some of the other board members chime in and say what their thoughts are on that.
Well, let me first, before we do that, because I think it's more important that we refer to Mr. Young and Mr. Vunich. We do have the opportunity, correct, gentlemen, to make a motion to postpone. And what would that entail?
Mr. Chair, if the board is inclined to take the time to review the information tonight, it would be appropriate to postpone consideration to the next regular meeting of the Board of Adjustment.
Okay.
And Mr. Chair, just so the board is aware, you closed the hearing, so the next meeting would just be an action on the request, not accepting further testimony.
Correct. It would be, correct me if I'm wrong, we would postpone and then would we go straight into a vote next meeting? Obviously, this, for lack of a better word, it's not relitigated, it's not rediscussed, not reevaluated.
The board can discuss it amongst themselves or go directly to a vote, correct?
Okay. Is this the appropriate venue to go straight to a vote? Are we in, I want to keep the discussion to a minimum here. So my thought would be to maybe ask one more time for a vote, a motion to approve, deny, or approve with conditions. And then if after a short pause, if it's appropriate, then ask for a motion to postpone. Is that fair enough? Okay. So I will again call for a vote for a motion to approve, to deny, or approve with conditions.
Okay, so all the discussion is over. Is that what you're saying?
Correct.
Well, before we vote, if that's what we're about to do, and I would like to vote and get this thing done tonight personally. I just want to make it clear in my mind, back to what John said, I think, in our closed meeting. In reality, we have.
Sir,
Just a moment, sir.
Sir,
Closed meetings need to stay closed. Please do
Correct.
not
Yes.
discuss what
Yeah,
occurred
yeah.
in the closed meeting.
Okay,
Yeah, I apologize, but yeah, we definitely don't want to discuss anything done. And the reason it was closed was for internal deliberations.
got it. Sorry. I'll just take it back to-
attorney-client privilege.
Yes.
Okay. Looking at it as a board.
Yeah. No, I understand.
Yeah, okay, I'm going to try to explain this.
You know, we're all
The way I
navigating.
understand,
Yep,
the way I understand the board.
Mhm.
What we heard a lot of stuff tonight we probably should have never heard. But what we're supposed to do, the bottom line of this whole thing is, would we have given the variance back in the beginning if they asked for it before all this started? And that's what we have to kind of look at it as, correct? In reality, this other crap that we heard tonight doesn't matter. Because we're not judges and we were like in a trial all night long, and we shouldn't have been. But what this is all about is this variance, and would it have been given with the information, if they knew they needed a 100-foot setback, and they came to us and asked for a variance, would we have given it to them? That's the question.
The question is to approve, deny, or approve with conditions the variance as it relates to the hardship or practical difficulty relating to the character of the property only. So to answer your question, correct.
Got it. And I'm assuming if that would have been presented, we had input from probably Mr. Busher.
I apologize. I do not mean to cut you off, Mr. Sides. I just want to be careful that we're not continuing to deliberate and discuss scenarios.
No, I'm trying to look at this as if I didn't hear any of this other stuff tonight, because I don't think in this kind of board, what I know of, that we should have heard it. It seems to me, this doesn't seem relative to me, but the thing is, if we were hearing about this variance for the first time and we knew there was a 100-foot setback, I'm assuming there would have been a sign posted, a hearing, and the neighbors would have had a chance to input.
It would have followed the proper.
So we would have had some other input. And so that's what we would be using to decide the yes or no on this variance.
Yes.
Just trying to clarify my mind. That's how it's supposed to be.
Oh, fair enough. Yes, the traditional way would follow just that. We would be evaluating the building proposed to be at the 31 foot, proposed to have this elevation, proposed to have this. We would, again, only be looking at the character of the property and where that building would be proposed.
Well, not 31 feet, it'd be 100 feet, because we're looking at it like everything was done right.
Well, no, well, then they wouldn't be in front of our board at that point. They wouldn't need a variance.
Gotcha, you're right.
They would only be coming in front of us to say we're at 31 feet because we can't go to 100. And we would then be looking at just the character of the property, of the building, what it's going to look like, what it's going to be. Obviously, you'd have input from affected neighbors, but again, we would not be evaluating if it's here to stay, it's gone tomorrow. We'd be evaluating simply the character of the property and doesn't necessitate a variance.
That's correct. Okay, I got it. I'm ready. If you're ready.
That being said, I think we all had a few minutes to think about a motion to approve, deny, or approve with conditions. Do I have a motion to postpone under the under the guidance of the city attorney to where we can discuss it amongst ourselves, but next time we convene will be to simply vote. Is that fair to say, Attorney Young?
That is correct, sir.
Okay. So
Well, I'll make a motion to postpone till the next meeting, with the understanding there'll be no more testimony or input or whatever. It's just literally to vote at that time. So I make that motion.
do I have a second for a motion to postpone till next month's meeting?
I guess I'll second that.
Thank you for the second, Mr. Rubus. We'll now call to a vote. Member Coleman, how do you vote?
Agree to postpone.
Yes. Member Sprunger,
Agree.
Member Sides,
I don't agree.
Mr. Rubus,
I agree.
and I agree as well. So the motion is passed to table this till next month for a vote. Anything else that we need to do, gentlemen, procedurally?
Oh, sir, that concludes that particular matter for this evening until the next meeting.
Okay. Before we sign off, and I know we're at this point, I don't know how the other members feel, but I would like to circle back with members of the city on this issue. Is that possible, or is that not?
In terms of substantive questions, sir, the hearing is in fact closed.
Correct. And yep, so we all have the materials. I imagine. I'm sorry.
Can we either before the next meeting or at the next meeting, can the board discuss among themselves? Would that mean that when we say among ourselves, that would be no city, no anything would not be able to join in or be present?
No, sir. So at the next meeting, after a motion, debate can be had on the motion. Now, if there's questions of clarifications pertaining to the record, yes, the staff can interject and assist with clarifying the record and information on the record.
Okay.
So to clarify my prior statement, I'm saying that the staff would not be there to be questioned about new information.
Okay, but the board members can freely discuss what their thoughts are.
Yes, sir.
Among themselves. Okay.
Okay.
Mr. Chair, if I may,
Yes, Director.
Mr. Young, I think Mr. Rubus is suggesting that there be discussions outside the outside the meeting structure itself.
No, no. I mean, we're at the meeting. We called
Okay.
the meeting order and we discussed there. I was just concerned whether when we started our discussion, would city staff have to leave the room?
No, sir, it'll be a fully public meeting with the staff, the typical attendees present, as well as any interested parties.
Okay.
Okay, so
And
to be
hopefully that'll
clear,
be in person.
I'm sorry?
I said,
No,
hopefully that.
I meant that metaphorically.
Oh,
to be clear, Mr. Young, so if I wanted to talk to Jared or Deborah or Dan or whoever, just like tomorrow, I want to pick up the phone and say, man, what do you think about this? I'm not supposed to do that?
I would discourage any conversation outside the scope of the meeting or outside of the confines of the meeting.
Okay, so, okay. Oh, man.
Postponed for nothing.
Okay,
What's-
well, I didn't,
what
I'm
will
sorry,
the
I did
date
not
of the-
realize that. If I would have realized that, I think I wouldn't have made that motion to wait. Because now all we're gonna do, if we can't really talk to people or whatever.
I think it best that we each take amongst ourselves, review all the information, slide all parties. We got a lot of exhibits tonight. with the intention that
Oh,
at next meeting, we will have a vote. So if you already feel a certain way, if you don't, either way, we've already agreed that it will be next month. And at that point would be the appropriate time to let it know by a vote. Anything before would be inappropriate. So.
Okay. Okay, that being the case, can I undo my motion?
No, sir.
Because I don't know that we're going to be able to do that much other than just, again, we can review on our own, etc. But I think part of the value of making wise decisions for the citizens of this city is that we're able to talk to each other, to hear each other's perspectives. And to me, that helps us clarify and come to a really great decision, a fair decision.
And you will absolutely have that opportunity at the next meeting to do that.
Correct. And I think at this point, we digest all the information and come prepared to do our duty and ask the questions and discuss it in the traditional setting next month in the public meeting.
We're supposed to remember all this stuff and review all this stuff. And you think we're going to be fresher about it in a month? I don't get it.
Yeah, frankly, I don't get it either. I'm sorry. And it's my fault. It's my fault. I did not realize that by making a motion to postpone means that, well, all the discussion's over until next month. I'm sorry, I did not realize that. And I'm with Dan a little bit on this now that, and I'm the guy who made the motion. You know, I don't know that we're going to be able to gain that much, because with time you just forget. And I think, but if you're telling me, too bad, water's under the bridge, we got to wait till next month, then that's what we'll do.
Correct.
So we'll do.
Okay. Then,
And Mr. Chair, just one last item. If you need to recall any component of tonight's conversation relative to this case, the proceedings will be posted on YouTube, the Wildwood channel. So you'll have that available as well, besides the information that's been provided by all parties. Thank you.
correct. And with that, unless there's anything else procedurally that Attorney Young or Director of Units would like to add, we will close this proceeding.
I have nothing, Mr. Chair.
That being said, we will close the proceeding.
Okay.
Thank you
Goodbye.
all.
Good night, everybody. Thank you for everybody's time.
Good night.
Good night.
Good night.
Good night.